I beg to mention for listing the petition.
Item number?
Not item number, Your Lordship. I beg to mention for a listing.
Okay. When do you want it?
24.
What?
24th, Lordship. 24th.
28.
Me please, your Lordship. Lordship, I beg to mention for listing, Lordship, criminal contempt petition, Lordship. Contempt petition, Lordship.
Or
Lordship, for orders, Lordship.
28.
20, Lordship.
Demarcation has been done, Lordship. That report, my lord, I have waited, Lordship. My lord, that today morning also I talked with the circle officer. He told me that, my lord, the survey department, they did not serve the, my lord, that report. So because of that, my lord, he could not be submitted the report.
So when can we get the report?
But within 2 weeks, 2 weeks.
2 weeks.
My lord, that has been prepared, my lord, that regarding the dark number 14-9.
Mr. Joy Hendig, the learned counsel appearing on behalf of the Revenue Department, Revenue,
No, it's that.
State Department, State Government, seeks for accommodation for 2 weeks to submit the report pertaining to demarcation being carried out. Full stop. This matter again on 11th of August 2025.
Can it be a week earlier? 2014 matter.
So
Already, my lord, this is my lord.
18th of August 2025.
Let it be on 11. 11.
Kindly password method for the timing one.
Huh?
My secret is also.
Yes, Mr. Chaudhary.
No, this is regarding settlement of a fishery.
Hmm.
There was an NIT, my lord. The first NIT, my lord, with the petitioner participated. And my lord, technical bid was open and thereafter financial bid was not open. But the petitioner learned that he is the highest bidder. Then my lord, nothing happened for a very long time. Then my lord, second NIT retender has been issued without cancelling the earlier my lord tenders. And in this tender, we have not participated because my guess is that, my lord, when it was the financial bid was opened and financial bid was also supposed to be opened on the same day as per their, my lord, the guidelines. It ought to have opened and, my lord, cancellation was bad. And subsequent, my lord, the tender NIT, that is, my lord, not within the, my lord, guidelines. The period, my lord, at least 15 days time is given to be required, that has not been given. These are the two basic
Now,
points.
first of all, your only case could be that you being the highest bidder in the earlier tender, the question of floating another tender without cancellation of the earlier tender does not arise. You cannot, you being out there, because you don't want to participate.
I don't know.
So therefore, the question of there being any illegality of 15 days does not come into the picture.
Otherwise, because I have to challenge the, my lord, subsequent tender. For the reason, two reasons, my lord. One reason is that, my lord, since earlier, my lord, NIT bid could have been, my lord, finalized. Within their guidelines, they have been not finalized. The other tender, retender is also, my lord, back. That is the, my lord.
So that is your only case is out there that the earlier tender, you were the highest bidder. And as such, they should have either given it to you, but without cancelling the entire process, they went for another bid. Tender.
Another point is that, as many as 22, my lord, fisheries were, my lord, tendered. And the entire, my lord, the retender has been carried out in respect of all the, my lord, 25. I am concerned with only one. And when the petition was moved during the holidays, my lord, a document was produced by the, my lord, this is showing that 5 of the bidders, they had given a wrong date in the affidavit. Instead of 17th, my lord, the date of NIT, it was 18th written in the affidavit, and that was done by 5%. And as such, my lord, the entire process has been cancelled. That is the ground, my lord, taken.
In respect to your fishery.
No, my lord, they do not speak specifically in respect of which fishery. My lord, affidavit is also wrong. I admit that, my lord. Now I find that, my lord, it was 17th, but we had written in the affidavit as 18. Although the, my lord, tender number was there. So that could not have. my
In
lord,
respect to your first tender.
They come up with the plea that 5 of the tenderers gave the date as 18 instead of 17. That's why the entire process has been cancelled. That is a document, my lord.
But that is a reason for cancellation.
That is, my lord, as per them. my
Now
lord.
the question is whether that reason is subject to judicial review. That's the only question.
I was not. It's the order, Lord. Well, the main thing is that my learned single council has stated that they are the
You were
highest bidder.
enjoying a vacation?
Yes, Lord.
Okay.
I was 10 days vacation, Lord.
Ah.
The last day.
We had staycations, my lord.
Actually, my learned friend is.
So your reason is on all the 5 bidders in respect to this.
We have not, Lordship, we have very interesting point, Lordship. My learned friend has raised, Lordship. They are saying that they are the highest bidder. But there are 5 bidders. We have not opened the financial bid. It is still paid. How they came to know that they are the highest bidder, Lordship? This is a intriguing part, Lordship. Very.
No financial bid opened.
No, finance bid was not.
How they know?
How do you know that you are the,
That is a.
unless there is a cartel?
No, my lord, when my lord, the bid shall
How do you
after
know?
the last date, after the last date, my lord, everyone says, what is your bid? I say that.
No,
That much
no.
happens. That is his knowledge. But
It is on the question of technical.
We have closed it because all the 5 bidders has same something we can produce a record. Lordship will go to all the 5 bidders has stated similar.
Let us see the tender condition. We are concerned with 2 of 2025.
They have not annexed it, Lordship.
my lord,
Then?
refund here.
How will we know?
Lordship, they are supposed to annex that petitioner, Lordship.
We have not enclosed the entire one.
Lordship.
My lord, the relevant part we have given, my lord, and that is my lord guideline.
No, no, the terms of the tender notice have to be mentioned. Here they are
No,
mentioning about clause 20.3 of the NIT. Where is the NIT?
That is not there, Lordship.
Then how this type of repetition is maintainable?
Yes, sir.
My lord, the relevant aspect has been given, my lord. It has to be filed, my lord, very short way.
You have opened the second tender
Yes, Lordship, already. 8 on 8, technical we have opened
on technical or financial.
on 8th of this month, July.
These are e-tenders.
Yes, 3 tenders. But they have not
Now,
participated.
are these e-tenders?
Physical tenders. Because
So why don't you allow him to participate in the second tender?
no, he cannot. You could have allowed. We have not debarred him, but he has not participated, Lordship.
No, my
And
lord,
he
the-
came to the court on 10th of July after completion. The matter becomes infractious on 10th July actually. When the order was passed on the last day, the matter is itself infractious because on 8th July, we have already opened the tender.
No, but the order is passed that not to make any settlement.
Only told not to make a resettlement. That is not, the order does not say that we can't open the financial. I think.
You. Considering let the matter be listed on here, meanwhile, till the next day, the department will not proceed for settlement in terms with the retender. Yes.
Sir, yes, Lordship, financial bid is not being state, Lordship. This documents was not considered, Lordship. This affidavit, that's order was not considered while passing this.
Now, then the question is, what about the 15 days?
15 days, Lordship. That's true, Lordship. My learned singer has said, rightly said that part 15 days notice is required. And I agree, Lordship, 13 days is been given. Lordship, in that case, Lordship, they are not the participant. They are not the bidders, Lordship. In that
They
case,
could have participated.
but they have not. Within 13 days, they have not.
What do they say in the petition?
They have not. They could have participated.
They have not stated in the petition, but my lord, they went to file the.
They could have,
tender,
they-
they were not allowed, my lord. That is what my instruction is.
As
That
you
is not
made
the
the
Supreme
mention,
Court.
When you heard it is, yeah, we are not,
no case.
for this Lordship, that they have to file.
Perhaps, my lord, if they produce the records, my lord, everything will be clear, my lord, why they have been cancelled, because, my lord, I have stated on
No,
affidavit.
they have already stated the reason why on the ground of
My-
technicality.
the Technical beach were open, and my lord, I was found technically suitable, my lord. Thereafter, on the ground of that.
How do you know that?
My lord, that, we were there, my lord, when the, my lord, the tenders were open.
How many bidders participate? All the five?
Five.
All the five? Then how do you know that the
All Lordship.
technical bid you were certified?
No, my lord, they declared it. that-
Where is the declaration?
that document- That's why,
Then
my lord, I say that, my lord, the records will reveal that.
the record
not a
categorically
reality.
says. Record categorically says out here that why it was decided.
Now the question, my lord, that rejection, all the, my lord, five
They
participants
have to, they have,
making a wrong
Calendar.
deed, all making a wrong deed is something, my lord, your worship will consider that is a defect which does not
we also,
prejudice anyone.
we can also suspect that all the bidders have similarly wrongly fill up, all the five bidders. Why? Only
That-
all the five bidders, why stated the wrong date? And they also know the financial bid, highest bid, Lordship. In that case, there is a,
Chalo,
there is
bring, you bring the records at 2 o'clock. We'll finish it.
Lordship, today, tomorrow, Lordship.
Well, not tomorrow, today. Bring it. We'll finish it off. Ask somebody else. Getting the records
Lordship,
is not a
can-
problem. I will only see as to whether all these five bidders. Dismiss his petition.
Make it a three, Lordship. Three, Lordship. Traffic jam is there.
Three. Okay, 3 o'clock. 3 o'clock.
Apply.
We'll finish it.
I know that.
Oblige.
Yes, Mr. Mahmood.
My lord. Long back time.
Ah,
My lord, there's a tender was called at
Hmm.
Sapotgarh Municipal Board.
hmm.
Several persons offered their candidates tender papers
Hmm.
in offline and online also.
Hmm.
In the long run, the statements of the tenderers were also published, that is page 27. And I was the lowest bidder. Lowest but reasonable bidder. Even then, my lord, the impute order was passed that lordship may kindly see page 40. Sorry, my lord, 39, page 39. There is no reason. Page 39 is the impute order.
Where is the tender document?
The documents
14,
here,
11, 20, page 20.
there. But they publish the.
You
notice.
participated in which one? Construction of boundary wall.
Number 2, page 20, serial number 2, construction of boundary wall on the northern and southern side of the Sapatgram Municipal Office premises under untied grant of 5th Finance Commission. And this is one of, and the next, there were 3 works, page 22. Serial number 3, 4, and 5. So here you also would see my tenders were the lowest, but reasonable. And I am first class contractor.
And what is this page 22?
Page 22 is the offline.
This has been done subsequently. Oh no.
The
Or
same
this is the
time.
online, this is the offline.
Yes.
Okay. Financial bid for construction of the boundary wall. Page 25. What is the name of the petitioner? Topos Kumar Lodh. Topos Kumar Lodh is which one?
Tapas Kumar Lodh's.
Okay, yeah. You quoted 10 lakhs 69,904.
Yes.
This is less by 15.81%. What is Annexure 7?
That's 7. Annexure 7 is summary details, page 27. onwards.
Yes, what is that?
That is one of the latest calculation they have made. Can you see now, page Tapas Kumar Lodh Rai, so 16 lakh 85,000.
Yeah, now this is why this is higher and the earlier one is less.
No, in total they have made this.
Huh?
In total they have
Who
made.
is paying for the government? This 6 and 7. Now what is this Annexure 6?
This is regarding, my lord, general public toilet.
Huh?
This is another item.
Construction of boundary wall. No, 25 is, page 25 is construction of boundary wall.
Yes.
And
is,
this
my
is
lord,
for
construction of
general public.
public toilet. Actually,
Yeah,
public toilet.
general public at, how do you know that this is toilet?
No, my lord, in the tender also it is written as general public, my lord. In the second tender, it was clarified, my lord, it was general public toilet.
Or this is a different one?
Yes, ma'am.
Where is it? A general public, construction of general public at Saptagram. This is 19 lakhs. So he has quoted 16 lakhs. Then, so here the petition I have quoted for everything.
Yes, ma'am.
There
Now,
are my lord, several works.
Mr. Mahmood, you are challenging everything.
Yes, all the.
In all the cases, you were the lowest bidder.
Yes, I am.
You have participated in all.
Not all in four cases, I was the lowest bidder. In that 4 cases, that is of line 3, kindly see page 22, serial number 3, 4, and 5, and page 20, serial number 2. So these 4 works. There were more than 4 works. As in these 4 works, I was the lowest bidder and reasonable bidder. So there is no reason absolutely to pass the impugned order. They did not want that this should be
So
the
these
case.
are all different works, different tenders.
Same,
No,
same tender, my lord,
tenders are
different
two.
item wise.
No, no, it can't be tenders being same.
Tender papers are-
You see the work at Annexure 3 is construction of boundary wall on the northern and southern side of Saptagram Municipal Office, so and so under the United Grant of 15 Finance Commission.
Yes.
Now, if you see page 22, this is construction of boundary wall included, including site development of proposed land allotted for STP of so and so under the 15. So this is a different work. So this offline tender and the online tender, these are different works. How are you filing in one writ petition or
By
everything?
once, same order, they can sell this.
So what? These are all different tenders.
Can you see page 10,
No, no, no.
page 39, annex 10?
Got a stay also.
Yes, my lord, not to.
My goodness, no stay business.
But kindly,
No, 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 no,
Appreciate.
nothing doing.
no,
First
no,
of all, we should.
Why a
No,
common order?
Mr. Mahmood, why on earth did you file one writ petition? On respect to a different tender altogether.
no, different tenders, but the impugned order was first, including all the tender.
So what? Where is the impugned order?
Page 39,
Both tender has been cancelled by this order.
And this notice is being invited for what?
no, that is, thereafter retender was issued,
Ah,
but that has been kept in abeyance because of Honorable High Court's order. That is because High Court said that this retender matter should not be finalized.
now you have not participated.
I wanted to participate, but they did not give me the papers because offline papers, those who were not found available. That they did not provide me. I wanted.
He filed an application after the date of filing of the tender papers.
Huh?
He filed an application for seeking the documents, my lord, after last date of.
Now tell me,
After High Court's order.
why you have come up with the lowest bidding? Means below the means what is the basis on which you have come to your finding? Because normally we follow Dr. Associates, just per as long, wherein unless you mention in your tender document that this is the lowest bid for which you want to cancel it. I mean, there will be some what is that term called?
10%.
No, Dr. Associates also said that viable rate.
Viable.
Yes,
You have not mentioned about any viable rate in your tender documents.
yes,
that is
that
not
is our case.
That is not mentioned in the tender.
So if it is not mentioned, then can you go into this thing that they will go and give it under the this particular amount which is there is much less and they would not be in a position to perform.
That is there, but even my lord, since my lord, in the interest of the work, my lord, because my lord, if low rate is quoted and it is offered, my lord, quality of the work may have been, my lord.
Well, that they may inspect, if I do any less quality constructions or works, then they may that is not their case. They cancel the matter immediately without showing any detailed reasons. Why? I am the lowest tender, I have a bona fide expectation that I will get. And not the lowest only, bona fide and reasonable. And why?
Now does the law change after Dr. Associates and just for as long?
It comes as in.
They cannot say, I am the first class contractor man. So why, how they can presume that I will do the bad work at the cost of my career?
first one regarding my lord, right of that tender does not require my lord first the right to contact my lord.
Huh?
Lowest or highest bidder, my lord. First one, my lord.
Which one?
My lord. Indoor Vikas Pradhikaran, my lord.
Indore Vikas Pradhikaran. Yes, what does it say?
12, my lord. One please. Paragraph 12, my lord. Internal page 8, my lord.
Paragraph?
Paragraph 12, my lord. 112. 112 to 15. My lord.
The undisputed revealed that the first NIT was issued on Iman and the NIT was certainly the highest bidder by offering Iman per square meter. The tender will, after examining the bid, arrive to the conclusion to cancel the tender as it came to the knowledge that an outstanding property demand amounting to Iman was not taken into account while fixing the base price, but resolved to issue a fresh NIT and thereafter fresh NIT was issued on for the reasons. So, but this is not on the viable rate.
Yes, my lord. Under no, yes, my lord.
Huh?
Yes, my lord. Yes, my lord. It is not on the viable rate, my lord.
We are only concerned with the viable rate. Now, has the law after Doctor Association Jaspi's law changed? I'm asking you that.
Exactly not on that, my lord.
Yes, government advocate. Who is appearing for the government? You are appearing for whom?
6 and 7, my lord. For a board, my lord.
6 and 7 is the board.
Yes, my lord. I can also appear for the other.
This is the municipal board.
Yes.
What about the other government, housing, urban development? He is appearing.
I can also represent.
You cannot appear. This is conflict. Yes, what is this concept of just, you see the law as regards which have been settled in Dr. Associates and this Jaspi's law says that unless you mention in your tender document that the tendering authority would consider a viable rate, you cannot put another condition later on that this is too less. Because the analogy or the justification given in Dr. Associates is that the person concerned is a prudent businessman knows what is required to be quoted. So unless you have anything in your tender document that we may consider the viable rate, like I think in some of your acts, there's a concept of a viable rate.
In respect of PWD department, we have a standing order that it should not be less than 10%.
It shouldn't be less than 10%.
10%.
So that is there in the PWD. But here in this case, there is nothing.
But I have not gone through the records. Frankly
Not
speaking.
necessary. On the position of law.
Position of, as regard the position of law, the viability is a vital aspect. That the viability of the rate,
Because there are certain,
because the standard has to be maintained.
very well, standard have to be maintained. There is no quarrel with that.
Madam.
Now, if they don't do it, then you can very well take any action against them. If they don't do it as per the viable rate, as per what they have quoted, your terms and conditions or your contract document which you are going to sign it categorically mentions most probably that they have to do a particular work in a particular manner. And if they don't do, you can very well take any action out there. Now, if there is no viable rate mentioned in the tender document, that is why I'm saying whether the law had changed after Dr. Associates and Jaspi's law,
But,
unless you put a viable rate or you may have in your technical, in your records earlier maintained in the records which you have maintained earlier, whether there is anything mentioned that you have considered that this is a viable rate.
But in fact, there are notifications from the finance department that in respect of tenders, the tendering authority has to follow some norms. Those are there, but the thing is that whether those are considered by the tendering authority before while taking the decision to float the tender, that is the question to be seen from the record of the authority. Otherwise, the position is clear. The subsequently condition cannot be put, but they can very well say in the tender document or in their decision that this is the lowest, and then nothing should go below that. That they can put.
They can very well say,
They can very well say
when, prior to that.
prior to initiation of the tender.
That is what, prior to initiation.
Right.
Later on, they cannot. That, look here, otherwise this will lead to arbitrariness.
Lordship will see, that is a yardstick that has been followed in respect of all the tenderers. So they may have a decision to that effect. It's a standing decision because the municipal boards, they used to issue tenders regularly. They may have a standing decision.
That is what I'm saying. Unless you have a standing decision, then look here. We have a decision to the effect that we won't give it below 10%. Or, yeah. Then in that regard, you cannot cancel the entire tender. You may give to anybody else who is not within 10%, because calling for tenders is also an expense.
Expense.
There is a lot of things which is required to be carried out.
But if that decision is there, they have a standing decision, then whoever puts below 15, he will not be eligible. His liability will be rejected.
Then you don't go for cancellation.
Whoever.
But who comes within the threshold? Just for example, you say that 10% is the mark. So then anybody who is the lowest with the 10% would come within the mean. But if you don't have that, this is a case for interference.
That from their record, they have to say.
No, they don't mention anything in the affidavit.
I'll call for that for my lord.
Why?
To ascertain my lord whether that decision is there.
Matter is over.
In the affidavit, it is not there.
Where is Jasper Ashlong's judgment? What judgment have you got?
Oh, I have, today I have got two judgments. That is our High Court, Gipchik Tami. That is para 47 and 47 to 49. And another one, this is Indra Marshall Power Private Limited. So para 20, 21, 22. So these two judgments also say that there cannot be any arbitrariness, and rules of game cannot be changed after game is over. This is the principle of law. So now, when they issued tenders, they did not say anything. Now many things are coming without showing any notice to me, without asking anything. And let's see the paras, relevant paras.
Mr. Mahmood, these are not your case. Your case is specifically covered by that judgment, those two judgments of Dr. Associates in here.
That is, that Lordship knows very well the Bible.
I don't know. I'm bench one. I congratulate you.
So I have a good case, my lord. Some order should be passed, my lord, asking to allow me to work. And if anything is
No,
found wrong-
I'm not going to do that. I'm only going to interfere with page 39. and thereby asking them to proceed in accordance with law. And 39 I am interfering with, and the consequential tender also goes for us. After we have the opinion that the entire process leading to the acceptance of the appellant is vitiated by more than one legal. Firstly, the tender notice did not specify the viability range, nor did it say that only tenders coming within the viability range would be considered. This is your judgment.
That is the Tattva yes.
Huh?
I know that, but I,
And the other one is just by as long. You have it?
I don't have the copy, ma'am.
But you have to choose, pick and choose one of the tenders. One offline and online. You cannot challenge so many in one writ petition. Which one do you choose?
my lord, it has been filed on 19/3/25. Several times it was listed, no learned judge did say this. This is the first time this question is
Chalo,
being asked.
let it be listed before some other learned judge who never says and like these things.
No, I am not on
Let it
that,
be
but
listed before that,
when there is
isn't it?
one single orders,
Let it be listed before any other judge.
no, I am not on that.
Then,
I only say that.
but
But
how on earth there is one tender that is different tender, this is different tender. All these tenders have been clubbed into. It is not the fault of the lawyer, the petitioner, the fault is of the council. So we impose a cost of 50,000 upon the council to be given to the legal service authority. What do you say? No, there is no poor man.
Lawyer's
No, no.
position is
No,
very.
you ask your client.
Then one, page 22.
No, page
No, I
22.
should be there. So page 22, that may be preferred one. That tender should be given to me. From the two, I have
So you are not insisting on the other one.
for the time being.
Not for the time being. The matter goes. So 39, page 39 remains good insofar as the other tenders, you give up your claim in respect to the online. But offline you only want.
At present,
No, there is no present. There is only one.
she has desired.
I am
So
not
I will
desiring.
file another case, I may file if the clients.
No, no, you cannot file any case.
The citation is for 2004-11 SSC 485.
Which one?
Just for
Just one. Page?
case number 485.
Well, I am using page 22, man. That may kindly be given to me.
I can't give you anything. I can only hold it this. Okay, take your seat. Let me dictate. Heard Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner. Mr. Nath, you will be appearing on behalf of the 1 to 5. 1 to 5, you can appear. Mr. D. Nath appears on behalf of the respondent numbers 1 to 5. And Mr. B. Setia,
M Setia.
M. Setia appears on behalf of the respondent number 6 and 7. The petitioner herein have challenged the Mr. Mahmood, you have not challenged this one, page annexure 10. Can I help you? You have not challenged annexure 10. This is the impugned decision.
Challenge the retender. She challenged the retender.
This is the decision which you need to challenge.
Written the notice was issued.
We are not concerned. You see, the decision that is consequential. You have to challenge this. You know the scope of 226 is very limited. In 227, I can do many things, but 226 is very limited, that too in contractual matters.
That's right. Power under 226 is wider than power article under.
Understood. But the power under 226 in contractual matters is limited. Here you need to challenge this notice. This is the order.
But prayer in prayer specific, but kindly see page 8, para 4.
No, that I can't help you. Because you see, this retender is not in respect to all the works. No, it is only in respect to 5 works.
5 works, but it has covered both the earlier 2 tenders work.
No, it covers only 1 and another 2 works in the tender. You have quoted for 4 or 5. Then
Yes, for 4 men. 4.
so, but this is not all the work which is being there.
That is, I have mentioned in page 8, para 4. That is, that Lordship may kindly taken
I can't help you.
the discussion in power. My lord.
I don't have the power.
No, your Lordship has the power.
No, I don't have.
That even that I will show your citation that this court order so much technically it is. If the party otherwise proves his case, there is and if there is any law, no law, then the discussion equity will come to my favor. Equity will come. Here it is clearly mentioned, which is from the tender time schedule, it appears that no bid opening that was mentioned in the schedule which is questionable. However, it is a matter of regret and discernment that instead of providing the tender work to the petitioner, being the lowest and reasonable bidder, the authority in Saffordgram Municipal Board cancelled both the tender notices by a notice that is so in a most colorable and unfair manner without assigning any reason. So, Lordship may kindly look into this matter.
The petitioner herein have assailed the cancellation of the offline and online tenders invited under the 15th Finance Commission wide SMB oblique 15th FC oblique 2024-25 oblique 460 dated 14/11/2024 and number SMB oblique 15th FC oblique 2024-25 oblique 461 dated 14/11/2024. On the ground that the same was unreasonable and unfair. Or on the ground that the same is unreasonable, unfair, and arbitrary. And is in violation to Article 14 of the Constitution. The consequential retender dated 6th of March 2025 issued by the respondent number 6 and 7 have also been assailed. By the present proceedings. In the backdrop of the above, the question therefore arises as to whether this court is required to exercise its powers of judicial review insofar as the decision of the respondent authorities, more particularly the respondent number 6 and 7, to cancel the tender and going for fresh tender, retender. Full stop. To understand that, to appreciate the same, this court finds it relevant to take note of the brief facts which led to the filing of the present proceedings. Full stop. The respondent number 6, through its executive officer, that is the respondent number 7, had issued a notice inviting tender bearing number SMB.15FC oblique 2024-25 oblique 460 dated 14/11/2024, inviting sealed tenders from eligible bidders in respect to 4 works as have been detailed out in the said notice inviting tender. The petitioner herein, who was otherwise eligible, participated in respect to the tender, participated in the said tender process in respect to the work, namely construction of boundary wall on the northern and southern side of Sapatgram Municipal Office premises under untied grant of 15 Finance Commission. Full stop. The relevance, full stop. Taking into account the relevance in respect to the present dispute, this court finds it pertinent to reproduce the details in respect to the work for which the petitioner participated pertaining to the tender in question. Full stop. Itu বাকিবোৰ নালাগে হা খালি এইটো লাগিব next on the same date the respondent number 6 through the respondent number 7 issued an invitation of bid in the offline mode or online mode. This is online, no? Online mode. Inviting bids from reputed Class C and above contractors, firms in respect to 5 works as detailed out in the said notice inviting invitation of bid. The petitioner, out of the 5 works as mentioned in the said invitation of bid, submitted his tender in respect to 3 works. First, the relevant, taking its relevance, comma, for the purpose of the present dispute, comma, the works in which the petitioner participated as detailed out in the invitation of bid is reproduced here in under. Page 22, that's the name of the work, 3, 4, and 5. It will give 5, 3. From the above quoted, full stop, this court have duly perused both the notice inviting tender dated 14/11/2024, as well as the invitation of bid dated 14/11/2024. And it is pertinent to mention that there is nothing mentioned in the said 2 documents enclosed as Annexure 3 and 4 to the present writ petition in respect of any viability range pertaining to the work in question. It is further relevant to take note of that along with the said notice inviting tender, e-tender, and it is very pertinent to mention that in the online, along with the invitation for bid, comma, a notice inviting e-tender dated 14/11/2024 was also issued, wherein the schedule of the time schedule was duly mentioned. Next. The record reveals from a perusal of Annexure 6, 7, 8, and 9. That the petitioner was the lowest bidder in respect to the 4 works for which the petitioner submitted his bid. First, it is pertinent to mention that in respect to the construction of the boundary wall on the northern and southern side of Saptagram Municipal Office premises under untied grant of 15 pay commission, finance commission. Though the estimated amount of the work was rupees 12,70,788, the petitioner quoted rupees 10,69,904.50. In respect to the construction of the general public at Sapatgram in the premises of Sapatgram Bengali Higher Secondary School, Ward number 2, Sapatgram under the tide grant of the 15th Finance Commission, though the estimated value of the work was rupees 19,82,658. The petitioner quoted 16,85,049.91. In respect to the construction of the general public of Sapatgram in the premises of Sapatgram Bengali Higher Secondary School, this is the same, na? Okay. In respect to the construction of the boundary wall, including the site development of the proposed land allotted for STP of Sapatgram Municipal Board in Ward number 8, Sapatgram under the tide grant of 15 Finance Commission. Though the estimated value of the work was rupees 28,38,486, the petitioner was the lowest bidder, quoting for 24,12,532.61 paisa. In respect to the improvement work on construction work of improvement of Sapatgram Municipal Cremation Ground, Samsan Ghat, bracket close, in Samsan Ghat to bracket close, in Ward number 8, Sapatgram under Unified Fund of 15 FC grant, though the estimated value of the work was rupees 35,71,731. The petitioner was the lowest bidder, quoting 30,35,046.44. Full stop. Subsequent thereto, subsequent thereto, the respondent number 7 had issued a notice on 17/2/2025, whereby it was informed to all concerned that the offline and online tender invited under the 15th Finance Commission, bid number SMB/15th FC /2024-25/460 dated 14/11/2024 and number SMB/15th FC /2024-25/461 dated 14/11/2024 was cancelled by the Technical Evaluation Committee of the 15th Finance Commission of Sapatgram Municipal Board. In pursuance thereto, a retender was issued in respect of 5 works on 6/3/2025, which included two works in respect to which the petitioner had submitted his tender earlier, isn't it? Only two works. Mr. Setia, only two works. I think it's 2 and 5.
5.
2 and 5, na? Two works. Full stop. The petitioner, being aggrieved, have approached this court by filing the present writ petition. And full stop. This court, by an order dated 19/3/2025, issued notice and further directed the respondents not to finalize the retender dated 6/3/2025. Full stop. The petitioner was also permitted to participate in the said retender dated 6/3/2025 if so advised. Full stop. Mr. Full stop. On behalf of the respondents, only the respondent number 6 and 7 had filed their affidavit in opposition. The stand so taken in the affidavit in opposition filed on 25/2025 is that a discussion was held amongst the amongst the members of the technical evaluation committee of Sapotgram Municipal Board on 16/1/2025, and a resolution was adopted that as the lowest offer rate, that is L1, against each work of the online and the offline tender was very low, it was decided unanimously has been mentioned as anonymously. Huh? Tenders have gone down. Decided not to accept the lowest rates to maintain the quality of work in public interest, and directed the executive officer Sapotgram Municipal Board to re-invite tender. There is no, however, full stop. The minutes of the meeting of 16/1/2025 have been enclosed as annexure Roman 3 to the affidavit in opposition filed by the respondent number 6 and 7. First off, the resolution, the said minutes, the contents of the said minutes being relevant is reproduced herein under. It is about the minutes of the meeting opera. It's Sapotgram Municipal Board, page 56 of the years. Full stop. It was further mentioned that the petitioner, though wanted to submit his tender, though sought for submission of his tender, but the same was rejected as the tender period was over. In the backdrop of the above, this court had duly heard the learned counsels appearing on behalf of the parties. Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, submitted that a perusal of both the offline and online tenders dated 14/11/2024 would show that there is no mention about any viability range. He therefore submitted that what action has been sought to be taken by the respondent authorities now is to exclude the petitioner, who was the lowest bidder, and thereby that too arbitrarily, unreasonably, and unfairly. And in order to allot the said work to some blue-eyed person. In that regard, he has referred to the judgment of the Supreme Court in the case of Datta Associates Private Limited versus Indo Mercantile Private Limited, reported in 1997, 1 SCC, page 53, as well as the judgment of the Supreme Court, as well as the judgment of the Supreme Court in the case of Jasper Ice Eslong versus State of Meghalaya and others, reported in 2004, 11 SCC 485. Anything more? No. Mr. M. Setia, Mr. Dina, the learned counsel appearing on behalf of the respondent numbers 1 to 5, submitted that as the tender has been issued only by the respondent numbers 6 and 7, the respondent numbers 1 to 5 otherwise have no role to play, for which no affidavit in opposition have been filed. He, however, submitted that in respect to certain departments, there are certain circulars. Circulars?
That's not a standard procedure.
Huh?
Standard procedure.
Instructions there. Executive instructions.
There's circulars oblique instructions, which imposes a viability range of 10%.
10% in veterinary it is 15%.
Huh?
In veterinary it is 15%.
10% or 15%, as the case may be. However, he is not aware as to whether in the urban development department there is any such circular. However, he is not aware as to whether the respondent number 6 and 7 had taken any decision prior to initiation of the notice inviting tenders, as well as the invitation of of the bids. Invitation of bids.
Do you have any standing order?
Invitation of bids about any viability rate, or the respondent number 6 and 7 have any standing orders in that regard. Full stop. Mr. M. Setia, the learned counsel appearing on behalf of the respondent number 6 and 7, have reiterated the stand so taken in the affidavit in opposition and submitted that the decision have been taking into account the quality of the work in question, in as much as a lower rate, by quoting a lower rate, then then the even quoting a very low rate, comma, it would impact on the quality of the work. And as such, in public interest, such a decision was taken. Anything more?
Yes, ma'am. That is respect, my lord. Yes.
Huh?
In that respect, my lord, I have.
In that regard, he has placed the judgment of the Supreme Court in the case of JSW Infrastructure Limited versus Kakad, Kakainada Seaports Limited, reported in 2017 4 SCC 170.
Paragraph 8 to 10.
Paragraph
8 to 10. The decision is bona fide and in public interest. Court should refrain from exercising judicial review, my lord. Another is, my lord, if the action suffers from malafide or intention in favor of someone or arbitrariness or perversity, then constitutional court can only enter.
This court, having heard the learned counsels appearing on behalf of the petitioner, finds it now relevant to take note of. It finds it now relevant to take into consideration as to whether the discussion, analysis, and this determination, heading good. From the materials on record, more particularly, the notice inviting tender dated 14/11/2024, as well as the invitation of bid dated 14/11/2024, there is no mention whatsoever about any viability range. It only stipulates the approximate value of the work, oblique, estimated value of the work, the record, there is no denial to the fact that in respect to the four construction works to which the petitioner submitted his tender, the petitioner was the lowest. It was the lowest bidder. It is also an admitted fact that the petitioner's bid was less than the estimated, than the approximate value oblique the estimated value. In fact, it is pertinent to mention that in respect to the construction work pertaining to the offline bid and pertaining to the notice inviting tender dated 14/11/2024, all the tenderers quoted below the approximate value. Full stop. In this regard, this court now finds it relevant to take note of the reason so assigned by the respondent number 6 and 7 in the affidavit, insofar as cancellation of both the offline and online bid process initiated on 14/11/2024. First, the affidavit in opposition only mentions that the lowest bidder, the amount quoted by the lowest bidder was very much low. And it was therefore decided not to accept the lowest rates to maintain the quality of the work in public interest. Full stop. In the foregoing sections of the present judgment, this court have also quoted the resolutions so adopted in the minutes of the meeting dated 16/1/2025. There is wherein also there is no mention as to why. There is only a mention that the committee, the technical evaluation committee, have decided not to accept the lowest rate to maintain the quality of the work in public interest. However, there is nothing on record to show that there is any further discussion or analysis as to why the work in question cannot be carried out at the lowest rate. First, this court now finds it very pertinent to take note of the judgment of the Supreme Court in the case of Datta Associates, which dealt with the aspect of viability range. Full stop. Paragraph 4 of the said judgment being relevant is reproduced hereinunder. Full stop. From a perusal of the above judgment, it would appear that if the respondent authorities were to consider that there is a viability range in respect to the tender condition, in respect to the work in question, the tender notice is required to include such terms in the notice inviting tender oblique the invitation of the bids, which is not there in the present proceedings. Full stop. Nothing has also been placed by the respondent number 6 and 7 before this court that there was any discussion prior to the notice inviting tender. No discussion, which is based on records that prior to the issuance of the notice inviting tender oblique the invitation of the bids, any viability range of the submission of the tender would be taken into consideration. First, this court further finds it relevant to take note of the judgment of the Supreme Court in the case of Jasper Islong, and more particularly at paragraph number 21, which is reproduced here in under. A perusal of the said judgment would show a perusal. First, the observations so made by the Supreme Court in this above quoted paragraph the observations made by the Supreme Court in the instant judgment has got has relevance. For the purpose of the present dispute, inasmuch as the work which the petitioner is required to perform inasmuch as the respondents inasmuch as the respondents who are the tendering authority can very well decide if the offer in question is very low. But in coming to such a decision, the respondents, that is the tendering authority, has to arrive at such a decision, has to arrive at such conclusion on the basis of certain materials that it is not possible on the part of a contractor to carry out the construction work with the amount so quoted, is not in a position, it's not possible for a contractor to carry out quality construction work with the amount so quoted. However, neither in the minutes of the meeting held on 16/1/2025, nor in the decisions so made on 17/12/2017, 1/2020.
16,
Huh?
17 now, next one.
17/1/2025. There is nothing mentioned in that regard. Even in the affidavit so filed, there is no mention as to why the respondent number 6 and 7 considered that the petitioner would not be in a position to provide quality construction work with the price so quoted. First. This court now finds it relevant to take note of the judgment so referred to by Mr. M. Setia, the learned counsel appearing on behalf of the respondent, number 6 and 7, that is JSW Infrastructure Limited, Supra, wherein, in respect to which the petition, the respondent, the counsel relies on paragraph number 8, 9, and 10. First, a perusal of the said judgment, the said paragraphs, in the opinion of this court, a perusal of the said paragraphs, in the opinion of this court, are well-settled principles of judicial restraint in review of administrative actions. The said principles do not, however, denude the power of this court under Article 2 to 6 of the Constitution to interfere with the decision-making process if such a decision is arbitrary, irrational, or perversity, or perverse on the face of the records. First, in the backdrop of the above discussions, it would be seen that the respondent authorities have decided to cancel the said online and offline bid initiated on 14/11/2024, merely on the ground that the lowest bidder had quoted a very low rate without taking into consideration as to whether the said rate, with the said rate, The petitioner herein could have performed quality contractual work. Full stop. The terms of the tender notice, oblique the invitation of the bid, do not in any manner affect the powers of the petitioner, of the tendering authority. No, restrain, yeah. The terms of the, do not in any manner affect the power of the tendering authority to call for to have discussions with the petitioner on the aspect as to whether the petitioner would be in a position to provide quality construction work at the rate quoted by the petitioner. Instead of doing the same, instead of adopting such a mode, the respondent tendering authority have cancelled the tenders on being tender and gone for fresh tender. This, in the opinion of this court, is unfair, unreasonable, irrational, as well as suffers from perversity. Considering the above, the instant writ petition stands disposed of with the following observations and directions. আর ওপৰত এটা লিখিব কোড কুৱেৰি, কোড কুৱেৰি এটা দি দিব, ওপৰত আফটাৰ এওঁলোক দুজনৰ আৰ্গুমেণ্টছ হৈ যোৱাৰ পিছত, just put a court query. During the course of the hearing, this court, what heading? This court inquired with Mr. M.U. Mahmood, the learned counsel appearing on behalf of the petitioner, as to whether the petitioner is still willing to perform the contractual work at the rate so quoted in his tender document. Mr. M.U. Mahmood, the learned counsel for the petitioner, submits that the petitioner gives an undertaking and has upon instruction submits that the petitioner is willing to extend the validity of his bid for how many days? From today?
60 days.
Eh?
60 days from the day of passing this order. As
No. These are works. How can you be? It has to be 180 days as per the notice in value, because you cannot now say that I'm not going to do.
the timetable which will be.
The timetable is there within 180 days.
Quality works and they will inspect if I do any.
No, that is okay. Submits that the petitioner, upon instructions, that the petitioner is willing to extend the validity of the bids so submitted in respect to the 4 contractual works for a period of 6 months from today. And in that regard, is also willing to submit an affidavit before the respondent number 6. Accordingly, the instant writ petition stands disposed of with the following observations and directions. The notice dated 7th bearing number SMB oblique 15th FC oblique 2024-25 oblique 669 dated 17/2/2025 issued by the respondent number 7 on behalf of the respondent number 6 is set aside and quashed. Full stop. Number 2. The retender process, the retender bearing number SMB.15th FC oblique 2024-25 oblique 721 dated 6th of March 2025 is set aside and quashed. Number 3. The respondent authorities, more particularly the respondent number 6, and more particularly the respondent authority, the respondent number 6 and 7, and more particularly the technical evaluation committee of the respondent number 6, it is directed to again review the technical technical parameters, the financial bids, and to come to a conclusion as to whether the petitioner, who is the lowest bidder in respect to the 4 works, it would be in a position to complete the work, perform quality work, quality construction material work on the basis of materials available on record. And in that regard, the respondent technical committee, evaluation committee, is further directed. And in that regard, the technical evaluation committee can also ask the petitioner to provide further, shall have discussions with the petitioner and provide, shall ask the discussions for the petitioner to evaluate as to whether the petitioner would be in a position to perform. So the said exercise be completed within 15 days from the date of the instant judgment. Within 15 days from the date of certified copy of the instant judgment is submitted to the respondent number 7. With above the instant petitions. That's disposed. Very difficult, Mr. Mahmood. These matters, you have to be very difficult to interfering, but then also still getting some flavor from being sitting in bench 1 for 6 months. I have given you something.
Here, it's 2006, 1 SCC 479, para 36, 37, and 64. Court always did not wait for statute to provide relief.
Huh?
Always, court should not always wait for the statute. If Constitution of India, Article 142, 136, inherent power of the court, power to mold relief, scope held discretionary jurisdiction of a court need not always be conferred by statute. So, many times, if there is no law, equity will come.
But then also you need to challenge, huh? Yes, anything has been done in that regard?
Have got the latest instructions yesterday. My instruction says that it was as per advice of the cabinet, it was placed before the Mines and Minerals Department. They have submitted their views. They have no objection, but the Industries Department, they have sent back the file and requesting us to resubmit the file. And in the meantime, in the department, the additional chief secretary has joined recently. The process is undergoing.
Now, because of the industries department, it is going on.
Lordship.
So what to do?
The industries department has sent back the file. We will resubmit the file again after meeting the necessary requirements.
Now, after, you see, I have seen an order passed on 5/4/2024. Then an affidavit has been filed by the deputy secretary wherein he says that will be prepared after 5/4/2024. That is after the expiry of 30 days from the date of which will be vetted again by the legislative department. Vetting of the rules, it will be sent to the cabinet approval. After the approval, final notification will be published in the Assam Gazette, and hence the rule will come into force, which will be probably a period of 1 month. Now,
After that, my lord, it was placed before the cabinet, and the
the cabinet then,
cabinet has, my lord, as per the decision of the cabinet, views of the LR, AG, the letter I have submitted to the irrigation, my lord. The cabinet has suggested us to take the views of the various authorities and the department, and accordingly it has been sent to the department. The views have been already taken, and the Mines and Minerals Department, they have already sent, concurred, they have no objection, my lord. But the Industries Department, they sought some, they have given some, the queries, and therefore it is under process.
we are in 2025. The process started in January 2024. Why is it taking such a long time?
But I in fact asked yesterday, one of the additional chief secretary of the department, he has recently
Now,
joined.
isn't it the norm that you have to have these rules? If you don't have it, it is going to be a chaotic. See, this aspect had been dealt with in the instant writ petition for another purpose. Although his case, if I remember correctly, is that these persons were retired after a particular age. Their case is that this is a case of illegal termination, taking into account that there was no standing orders in respect to this industry. So therefore, the question of they having to retire on age of 60 or 65 does not arise, isn't it?
58.
So whereas the central government has its rules, the Assam government is required to have these rules. There's no quarrel with that.
No, that's true.
But why is the Assam government slowing it down? This is for the benefit of the people. This is for the benefit of the industries. On one hand, you are going for advantage Assam and you don't have that rules. Tomorrow, industries are going to come. Some industries may not have their standing orders. Then what is going to happen?
This order is required. This order has to be.
The High Court, the government of Assam is in the mood that it is because the High Court is looking into it. Why should we be bothered with these things? Why should we be bothered? We'll do whenever we feel like. But isn't it in the interest of the state that this is required to be done? This matter could have been otherwise disposed of on the basis of what is there. This bifurcation has been taken out so that something happens at the end of the day.
Yes.
Yeah. Why you are not being able to impress upon these government officials to do something in their interest of the state?
But from our side, we have been taking, we are taking up the matter. But because of some procedural reason.
That day I was looking into another aspect. In 2023, I passed a judgment. Now there are a lot of recovery was made on account of wrong noting in the service books. So in that judgment, I think in the month of February or March 2023, I said that why this can't be digitalized. If this is required to be digital, the service records. But Assam government have not done it. In the meantime, now you see the central government have also done that. Because now if you are going for everything digitalized or everything which is there, because you cannot keep on having a prehistoric thing out here today. That in respect to these people, the persons out there, there is nothing out there, so the state government is not going to do. The central government rules came in the year 1988, if I'm not wrong. We are another, how much? 25 and we are 37 years. 37 years, the state government has nothing to, and it is this court who have started the process. It is not coming in.
In fact, draft has been notified and the process has been undertaken. But
The
because of,
problem which is happening is the matter was taken up by me earlier. And
for some dates.
then the matter, this started in 2023. The process started in 2023, on
Yes.
23/1/2023. Then the matter was taken out from my side.
23/1.
And thereupon the matter was just going on.
Well, I have in fact asked them after receipt of the letter yesterday. I have asked them that you give us an outer limit because ultimately I have to advise the honorable court. I'm awaiting that for that, but the outer limit, the additional chief secretary, he is looking up to the matter. Yes, just recently. And from the conversation, I find that they are serious, what they are about to do, but the procedural parts, it's taking time. So what I have.
No, the procedure you have already done that. You have gone for notification.
That has been done.
Then you have gone for the 30 days of which is there asking, that has also been done. Then it has been also notified. Then it has been laid before the cabinet. Now the cabinet places for instructions from AR, from industry department. Now the industry department has to take a call. And more particularly when Assam wants to grow, instead of basing itself only on tea industry, also wants to do something on the other industries.
The what is the exact observation of the industry department, that I don't know. But from the letter I could gather that the industry department has sent back the file to the department, to the labor department. Labor department has to revert back. And it is under process of what they are doing and the outer limit, that these are the two queries I have made, and I'm waiting for that. I'll apprise you on the court.
When can we have something? Or should we have that industry department business council out here?
Well, let me have the instruction.
When?
Next week.
This was given when?
Yesterday I received.
Yesterday.
On 14/7/25.
Should I keep it as partnered?
Lordship.
Then only things will move.
I also think so.
Because my last order was on 23/1/2024. And we have 15 months down the line, nothing has happened.
The process is going on, but ultimately it has not been.
The push is required, isn't it?
Yes, absolutely. There is no doubt about it.
Heard Mr. A. Dasgupta, the learned senior counsel, assisted by so-and-so. Mr. D. Nath appears on behalf of the government of Assam, and Mr. So-and-so S. Das appears on behalf of the private respondents. The record reveals that the Assam Industrial and Employment Standing Orders Amendment Draft Rules 2005. Have not yet been brought into force. Though it is essential that the state of Assam also has a similar has also should have essential for the state of Assam, which is now preparing itself which is now taking steps for fostering industrial growth in the state of Assam. Insofar as the central government is concerned, they have already a draft rule. They have already rules. That is the Industrial Employment Standing Orders Central Rules 1946. This could further takes note of the instructions so placed by the Learned Council appearing on behalf of the state government that a matter has been placed before the Industries, Commerce and Public Enterprise Department for their inputs. Mr. Dinath, the learned counsel submits that on the basis of his instructions that the Industries, Commerce and the Public Enterprise Department of the government of Assam have have placed the matter again before the Labor Department of the government of Assam. For additional inputs from the Labor Department. And the said process is presently been undergoing, and the said process is being carried out. He therefore submits that some time may be granted for giving a more clearer picture in respect to the notification of the Assam Industrial Employment Standing Orders Amendment Rules 2024. List the matter again on 18th of August 2024 for an update. The registry. The matter having been heard at length. The registry shall list the matter at the top of the list, showing it as part heard.
My instructions will be kept on. My instructions.
And the instructions, how they have kept, all other instructions have not been kept. Na? So the registry shall compile the various instructions which have been placed from time to time before this court by the government from the in a separate file, as the same would be convenient for the adjudication of the present dispute. Separate file and tagged along with the present petition for the proper adjudication.
I have challenged the order dated 21/10/2018 passed by the Appellate Authority of APDC and as well as the review order, whereby
What order you are challenging?
the appellate order as well as the review order, both the orders
Why the order dated passed in appeal number in month?
authority.
Huh?
Appellate authority and the review authority. Rejected the final whereby
Have rejected the? And you are selling it.
Exonerated the consumer lordship in by appellate forum, exonerated the present respondent lordship from paying the provisional assessment bill because there was some wrong calculation by the vigilance department of the APDC.
So this is an appeal under 127.
Yes.
So you are initiating a writ in the Fishery, challenging that order. What is the mistake?
Lordship, my only point is that Lordship, at page 21 of the repetition,
Page?
page 21. Bill number 13, Lordship. Bill number 13. Initial load was 620 kilowatt as per record. Connected load original 425 kilowatt. connected load found 607,805.805 kilowatts. So
Hmm.
they were using 182 kilowatts.
Huh?
There was an excess of 180.
Sanction load is 620.
Yes,
Connected load is 607.
connected load found 607.
Then,
Connected load original was 425.
then
So they were using excess 125.805 kilowatts.
how is there excess?
Because Lordship, it was found, the connected load was found as 607. So when the original load was given as 425, they cannot use it excess than 425. Because if they want to use then the original connected load, then they has to seek an authorization or a notice has to be given to the IPDCL. That is not given in.
Show me that. On what basis you are saying? If the consumer at any time after the supply of energy has been connected, desire to increase the number or size of the light fans in his presence. That may be with also the position of his wife. No. This, how does this have any relevance?
Because once they,
First of all, what is this sanction load?
the sanction load was 620.
What is the sanction load?
Maximum connected load,
Take a seat, mister.
maximum connected load as per section,
Maximum
connected load in kilowatt or KVA delivered at the
connected
point.
load is means aggregate of the manufacturer's rated capacity of all energy. Sanction load is where?
At 13.
Means the maximum connected load in KW delivered at the point of commencement of the supply of the consumer at his premises sanctioned by the Iman in any manner. Okay. Now this is the sanction load.
Yeah.
Now he has 625,
That is the
620.
sanction.
620 is his sanction load.
Sanction.
Now what is this connected load?
Connected load, your Lordship will find
Means the aggregate of the manufacturer's rated capacity of all
all the
energy
energy
consuming demand connected with the distribution license means in the consumer's installation and which can be simultaneous. This can be expressed in so and shall be determined as per the procedure laid down by the licensee with the approval of the commissioner. Then connected load is the one which is being used.
Yes.
Which is being used. Now, if he wants to increase,
yes.
now how do you give the sanction load?
It's based on his application. That 5.3 specifically says that 5.3.
5.3 is different. I'm not on that. See, you have to 5.3 second part if you see, if
Yes.
as a result of such proposed extension and alteration, there is possibility of an increase in the connected load over the sanction demand. So it is, if the connected load is over the sanction demand, then you need to shall take steps to submit requisition for additional connected load.
First
Now,
part,
just for example, a person may seek a sanction of a sanction load. Here in this case, he has taken a sanction load of 625. Now, he may, if he has a sanction load of 625, does he have to pay something for that?
Yes.
He has to pay.
Yes.
The moment he has a sanction load, there is a certain amount he has to pay for that per kilowatt. Isn't it? Now, if he pays that particular amount, what is the point in if he has just for example 619 also?
But fixed charge is paid only in the connected, original connected.
Huh?
Fixed charge is paid only in the original connected load.
Where is that?
But
That
not
is
in
what
the-
I'm saying. Huh? That is clause which one? And how much one pays for sanction load? Show me that. Show me the difference between connected load and the sanction load. That I understand what is connected load in here. Now, how do you apply for connected load and sanction load? Mr. Counsel, you have not read your file properly.
Lordship, the file was given.
Then why are you preparing like this?
If your lordship grant me 1 week time, I'll.
This is the issue. Your issue is this, most probably, which I have not looked into. 625 is his sanction load. His connected load is 425 or something. At the time of inspection, it was found that he had a connected load of 607. So against this, you are charging him certain amount.
Yeah.
That's it. For that, you are not going to look into this. You have to look into that book. Where's that other book? There's one book, regulation. You don't have that book. You have arguing on a different aspect. And I think the answer would be there in the appellate forum's order. Let's see. Appellate authority must have said it.
Then your lordship will find correct. Lordship will find.
Gone through the single line, therefore, the electrical circle approved by the senior and found the dwelling. No, Mr. Council, you are going into another aspect. Kindly see page 84 and 85. Yes, Mr. Pathak, come here. You are the expert in electricity. What is this sanction load and what is this connected load?
Nomenclatures for load. One is the connected load, which is the load, which is actually.
When
total of
all the
appliances
instruments,
in the premise, that is the connected load. The sanction load is what is actually sanctioned by the distribution company. And there is something also called sometimes contract load. Perhaps that may not be an issue in this matter. So
contracted demand.
yes, contracted demand is, your lordship, for high tension consumers, for example, maybe tea industries. So they have a seasonal peak season and an off season. So what the contract demand says is my connected load will be say 100, but during peak season only I'll use at 100. So the rest of the year, the off season months, I'll build at maybe 70% or 50% depending upon the contract. So that is the contract. So if you cross that, that would incur some penalty.
Means you cross the
Contract demand, even though it is within your connected load, if you cross the contract may stipulate certain penalty.
just for example, in the tea industry, the manufacturing happens in the month of April to November. So there they will be used with the connected load.
Maybe it might be less or more in the connected load also depending upon the contract. But during the rest of the year, they will be billed at a tariff which is less than the connected load because they contracted we don't require the.
So at that point of time, if there is an inspection being carried out,
Yes.
and then it is being found that it is beyond that what is given in those periods, just for example, in December to March, there is less of work in the tea industry. So during that period, if anything happens, it is you means at that point of time you must be having a contracted demand. Just for example, at that point of time he'll be using, otherwise he'll be using 400. Here we'll be using 100. So if he uses more than 100, then there will be some amount which has to be paid.
There has to be.
But that is again dependent upon an inspection being carried out.
Yes. And there has to be some determination that he is actually exceeding that.
So, but one is sanction load. Means what is sanction? Just for example, in a tea industry, the sanction would be, in this case, although it's not a tea industry, the sanction was 625. Now, when do you give a sanction load?
That will be, in fact, usually agreements, for example, the contract would have an annexure containing the sanction load and the contract demand.
Now, what happens? Just for example, can a person ask for sanction of any amount?
No, there is a category chart, your lordship, as per the supply code, where the maximum possible sanction load for each category of industry, domestic consumers, high tension, low tension consumers, that is given.
Okay, so this is a sanction load. Now, when you get a sanction load, is there any amount which is to be paid for that?
Yes, your lordship. While applying for it, depending upon my category, some amounts have to be paid.
Just for example, a person takes 400 kilowatt and one takes 600 kilowatt.
Yes.
Then he will have to pay some additional monthly recurring or one time.
So I think there is some additional surcharge depending upon the category, because 400 and 600, I presume, may be different categories.
Okay. Now, once you have a sanction load, then you have a connected load.
The connected load, your lordship, is what is the sum of all the appliances used within the premise.
That I understand what is connected load.
Yes.
But the question is, if you have a connected load, if it goes beyond the sanction load, then obviously it is a case of penalty. But if you have a connected load, but not a contractual demand, if you have a connected load,
Yes.
is it against a particular amount which is fixed that just for example, in this case, 425 was his connected load.
Yes.
But his sanction load is 625.
Yes, then since there is no contract demand, then the only parameter which against the which the connected load can be judged is the sanction load.
So he can very well use it. So there cannot be a push of penalty out there.
If there is no contract demand, then there cannot, he has not exceeded the maximum sanction load.
So therefore, when he was referring to clause 5.3 of that, it shows that the second part therefore shows that if a person, while having a contracted demand, but it goes beyond the second part. If as a result of proposed extension and alteration, there is a possibility of an increase in connected load
So this action.
over the sanction demand. That means if it goes beyond, then you have to make a request.
Yes.
Otherwise, no.
Otherwise, because
Because it is already, when you are getting a sanction demand, as far as I know,
he's already paying for it.
he's already paying for that.
Paying.
So therefore, if you have a contract demand above that, the connected load above the sanction, then obviously there is a question of theft, penalty, whatever maybe, these things can happen.
Yes.
But otherwise it cannot. Now, therefore, your basis is wrong. Why you are coming? See, the fundamentals out here, which is being said out here, at page 84 and 85 of the impute judgment, is on the determination of facts by the appellate authority. And the appellate authority under 127 can very well determine the facts this way or that way. But for this court to exercise writ, how can it do so? Unless there is a strong case of perversity. That's the problem, isn't it? What to do? You don't leave it to me like this. But your fundamental of your argument was wrong. Because this is a finding of fact. Kindly see page 84, 85. In the last 5 lines, in the given case, I find no damage was caused by the appellant in the metering system, and no damage was made to the equipments, apparatus of the industry. Only painting, which I believe can be removed, was made in the specification plates as per the said inspection report of EVA. However, I do not want to comment on the said FI as I believe the law will take. But from the energy consumption and the maximum demand data, it is found that appellant never violated the contracted demand of 350 kVA. Had there been an excess use of connected load, the demand would have crossed the contracted demand. Further, as noted above, a re-verification of the changeover system would have made the inspection report transparent without any contradiction. As from the record, it is seen that the total load of 318.5 HP is equals to 2 sigma was assessed additionally considering non-existence of changeover system. Now, if we deduct so and so from the detected so and so, then the connected load will be so and so. Whereas the approved SLD clearly shows that the total load of the industry is so and so, which is within the authorized connected load of Fukushima and was being supplied power through APDCL's approved 750 in my opinion, the assessment conducted is erroneous. Now, how do I interfere under 226? Help him out.
Apart from that, Lord say, it is a limited company. There is no resolution from the board of directors for preferring this writ petition, Lord. Because under the Companies Act, Lord say, until unless the board of directors passes a resolution for filing the writ petition, Lord say, it cannot be looked into, Lord.
That we will consider when I'm again back to bench one. But now for this purpose, what
No,
is
it is
there?
also applicable in writ also.
This is a question of, unless there is a strong case of perversity. Okay. Finding of fact. Hello, we come back. At 3 o'clock, we'll take up this matter. Prior to that, I have two other matters.
Three.
You just find out anything you have to say out, because that is the issue.
In 2023. I have participated in item number 18, construction of line canal of Bainara, FIS under PMKY HKKP for the year 2021 and 2022. Also, you will find at page 24. Page 24 is the beach.
So you participated in this tender process.
Yes, sir.
Thereafter,
Thereafter, technical bids were issued
Hmm.
and
you
there were financial bids were also
technical bid, you were qualified.
qualified. Financial bid also I was qualified. Financial bid also will find at page 195. One 95, serial number 1 within the petition about.
All are L1.
All are L1, all the three are.
But it was given to Jitupal Deka.
GT Gold data.
Why?
So he is the work of the interim work order was issued on 25/9/2023. He has not executed the work also. Where is the stay order?
What is their stand?
Their stand is there. They have filed the epidemic lawsuit in paragraph. In
Paragraph 12 basically, my lord.
paragraph 7. At 207 lawsuit. This is their stand.
What happens when both are technically qualified?
3% are technically qualified.
Then if 3% are qualified and their bid is the same, then how do you give it as per your
Then
tender?
Lordship will have to turn to page number 47 of the petition. There is a clause when bid will be same, the 29.4.
46 years.
47. It starts from 46, 11 portion is 47.
Clause 6 clause.
Clause six.
In case of more than one bidder stands L1 as per the comparative, the bidder having the highest annual turnover during the last 3 financial years, higher value of single work order in a similar nature of work, and higher number of equipments proposed to be used for the work shall get preference in a work. The renewal shall be considered as 40% for a single work, 35% and so here he has 81 lakhs. Respond number 5, and he has 71.
74.
Another is equipment. Because they have, here the petitioner has given the equipment, the respondent also given. It is, have given 2 lists of equipment of different. There is, because there is two lists has been given, saying different things. my lord.
If your lordship comes to 128, page 128, it's the list of equipment. lordship. Is the list of equipment of the petitioner.
Of the
The petitioner. Excavator, JCB, lease 1, welding machine owned 1, DG set owned 1, mixer machine owned one, water pump 10 HP, owned one.
Next page is the affidavit, the equipments are different.
Huh?
Next page is the affidavit, on affidavit, the equipments are different.
All the same lottery.
Excavator, it is that page 28, it is lease. There is no information whether it is lease or something else. Now it's serial number 9, it said there are 200 is there. And in page number 28, there is only one. So the equipments, these are different. In on paper, on the question 28 is different, in affidavit it is different.
Really, Delta lottery.
But you have not cancelled it on that ground. The technical qualification is not there. It seems to be only on the base of this paragraph there. Paragraph number 12
Breakup
is
number
your
12.
answer.
Cancellation is, well, if you document.
That with regard to the high value single work of similar nature with completion survey, the writ petitioner has completed single order value of rupees 74 lakhs, whereas the respondent number 5 has completed 81 lakhs.
Next paragraph, my lord, sub-paragraph.
Lordship, one thing, Lordship. What he has done, he is the contractor of the PWD roads division, Lordship. He has no experience in the irrigation department, Lordship. Therefore, he has not executed it. In spite of service of notice by Dusty, he has received the copy of the writ petition, but he did not appear. He did not appear because he has no knowledge of the work of the irrigation department. And I have the vast knowledge, Lordship. I was all along.
Does it mention that the work order, single work order, let us see what are the requirements? Evaluation of comparison. What is the requirement of correction? Opening, bid values, billing market. Submission of only one bid will be accepted, option one. Security, financial information, technical bid.
Page 34 is the qualification of bidders. 34 and 35.
Qualification of bidders. See, page 34. Experience in works under the irrigation department. Does he have it?
No, no, he is not doing the that PWD.
Page 34C, qualification, all bidders shall furnish the following information. Financially sound and all, copy of the original regarding experience in work under the irrigation department.
In the last sheet.
Statement of money value of construction work performed during the last 3 years under the irrigation department.
Now, Lordship, if your Lordship comes to page 179 and 180, work done by the respondent, PWD.
170,
179 and 180.
construction of work, PWD.
You see,
This
block
is
from
81 lakhs.
the PWD for the year 2022.
Construction of work. Does he have any experience over in irrigation department?
No, no.
Mr. Bora?
Work done by the petitioner at page 116.
Hmm?
Page 116, Lordship will find the work done by the petitioner. Signed by the executive engineer. Irrigation.
Who has the highest annual turnover during the three previous financial years? Higher value of work, single work in similar nature of work,
149, page 149. The
and higher number of equipments proposed to be used for the work shall get preference.
Lordship, this is 149, this is the particulars of the gross annual turnover.
Hmm?
Petitioner.
Huh?
Page 149, this is the gross annual turnover of the petition.
Page?
149, 149. Two 2019, 2020, 86 lakhs 88,790. In 2021, 22 lakhs.
86 lakhs 88,790.
Yes.
Then 2020-21 no work.
22 lakhs 75,800.
So this is way less. And what about the other one?
Other one, Lordship,
On page 140, page
One?
141, page 141, my lord. Okay.
141 is submission of tender. No, not
There is
that
the
one.
financial turnover. 149.
140? 149 is this Jitu Poldeka. And what about the petitioner?
This is actually page now 97.
95. 90?
7.
Oh. Petitioner is better. Mister?
Same time, another issue, my lord, regarding page number 87, there is a labor certificate needed for everybody.
Huh?
It was a labor certificate, page 87. That is a labor certificate that has expired even before the issuing of the tender. It has expired on 11/1/2023. Tender was issued on 4/2/2023.
But there, for that you should have technically disqualified him. Isn't it? Up-to-date labor license, including details of EPF and ESIC. So you didn't have a labor license.
But subsequently I have renewed it.
When? But you are not going on the question. This is a technical thing.
Yes.
You have qualified him.
Technical thing, they've in the financial bid itself, when opening the financial bid, you will see the minutes, my lord. Then they said that the all have quoted below 10% and accepted, and work order of so and so has been given to the respondent number,
Page.
page 195.
There's no reason given.
No
I
reason.
have no reason. That is
Then just he
195,
liked him.
Like, my lord, this is good.
The BTC person must have liked him space more. Although he has a higher turnover. Petitioner.
The license is, trade license is not there and
It is technical.
one effect is the trade, labor license is not there, up to date.
That is not the reason why. You cannot do this. Because you have, you should have,
Per license, second is the equipment, they have a two list, this doesn't tell you, my lord.
huh?
He has given two lists, this doesn't tell you. I have shown you.
That is not your ground. Here we are only concerned with whether there was a proper application of clause.
All the equipment plus, my lord.
No, we are not concerned with that.
That is
We are
29
only concerned with
29.
as to 29.6.
29.6.
29.6 that last 3 financial years, the person who has the highest single order. First is annual turnover. Annual turnover is petitioner is better. Highest single work order, the response number 5 is better. Higher number of equipments proposed to be used for the work is similar, both are having same.
Yes. They are having almost the same, but they have given a two list on it.
That is not the question, you have not done that, but both of them are having the same,
More or less the same.
not more or less. Let us see what it is. 1:1 it is done, but what about the other one?
It's page number. Krishna is on page 128.
Hmm?
128. That's what it is. List of equipment.
128, he has given Tagari Balsa and all these things. They have given it properly.
Not only 163.
Here 200. Here he has, your person has given 100. Where is I have seen he's also somewhere.
163.
160.
Private respondent. Yeah.
One number of capacity, JCB 1, welding machine 1, DG set 1, mixer 1, water pump 1, 5 HP 1, truck 1, Tagari Belsa 100, that is 200. He has a vibrator. Huh? This person is less. Jitu Pol Deka.
It doesn't have the.
He has a Kudal.
That's it, private.
Then
That's better.
and what about the other one? Other fellow.
Other fellow, my lord, here,
The number 2.
there are three. Only
There are 3. Petitioner is here, the response number 5 is there.
And he has not met the party, the other fellow.
No, why should I? Because he was not
Yes,
awarded
and
the
the
contract.
Jitul Dek has
He was
given,
not awarded the.
he was not awarded that contract.
Work order was issued to the Municipal responsible 5.
Fellow, we interfere with this award and direct these authorities to properly assess in terms with 29.6. That's the only way.
Reassessment was quite pending.
It would not be proper on the part of
Page
this.
number 195. 195. Because there, that's
195, we interfere with this as well as the by which he was given the contract. This one,
space.
this 192. We interfere with 192 and 195. Okay, and direct them to consider strictly in terms with this. Matter over.
It's probably suffering loss. Because the two monsoons has gone down. These are the irrigation department.
No, in these type of matters, apart from that, what happens is, if the matter remains pending for a long time, it is also affects the contractor because he has quoted a particular price and this price will go up. It cannot remain the same with an inflation on which we are going.
So it comes up that someone will be benefited, all these farmers.
Yes. And the entire completion period is 12 months. 12 months is over. So let us do some public service. Heard Mr. Ardhor, the learned counsel appearing on behalf of the petitioner. Mr. S. Bora appears on behalf of the respondent numbers
1, 2, 3, and 4.
1, 2, 3, and 4. Full stop. 1 to 4. None has appeared on behalf of the respondent number 5 on call. Full stop. The petitioner herein has invoked the supervisory jurisdiction, has invoked the extraordinary jurisdiction of this court under Article 226 of the Constitution, challenging the
25 page 1.
challenging the minutes of the financial bid evaluation committee meeting held on 21/7/2023, as well as the notice to proceed with the work issued in favor of the respondent number 5 dated 25/9/2023. Full stop. The on the ground, full stop, no, on the ground that the respondent authorities have allotted the work in favor of the respondent number 5 in gross violation to clause 29 Roman 6 of the invitation for bids of the, what is this? Of the instruction to bidders in as much as without any rhyme or reason, comma, the respondent authorities have allotted the work in favor of the respondent number 5. Full stop. Taking into account the instant writ petition hinges on compliance to clause 29 Roman 6 of the instruction to the bidders. The said clause is reproduced herein under page 47 of this. Full stop. Let this court prior to full stop. In the backdrop of the above, it is put it here in full stop. From the above quoted clause, it would be seen that if there are more than one bidder who stands as L1 as per the comparative statement of financial bids, the respondent authority, the tendering authority, shall give preference while awarding the contract by taking into consideration 3 aspects. Number Roman 1, the bidder having higher annual turnover during the 3 previous financial years. Roman 2, higher value of the single work order in similar nature of works. And number 3, higher number of equipments proposed to be used for the work. Full stop. For deciding as to whether the respondent authorities have duly applied Rule 29, Clause 29(6) in the proper perspective, and in doing so, whether there was any illegality in allotting the work in favor of the respondent number 5, comma, this court finds it relevant to take into consideration the facts which led to the filing of the present writ petition. The record reveals next that on 4/2/2023, the Council of Head of the Department, Irrigation, BTC Kokrajhar, had issued a notice, an invitation for bids for different works of 100 new SMI schemes, bracket BTC, under PMKSY, bracket KHKKP, bracket close, for the year 2021-22, bracket open, in 24 numbers of groups. The approximate value of the work was rupees 56,87,33,012, and the period of completion was 12 months. You participated in which one?
In
Huh?
group number 18. At page 27.
Construction of line canal, na?
Yes. That
Good
can-
stuff.
Fine.
It is relevant to take note of that the present petition relates only to the construction of line canal of Bainara FIS, BAINARA, FIS, under PMKSY _ HKKP for the year 2021-22 of the Paneri Kalaigaon division, and the group and the value, estimated value, was rupees 17,834 1,72,34,800. And the period of completion was 12 months. The record reveals that the petitioner, along with the respondent number 5 and others, participated in the said tender process. Relevant herein to take note of that amongst the various documents to be submitted in terms with clause 4 of the instruction to the bidders, clause C, 4C, stipulates experience in works under the irrigation department during the last 3 years, bracket if any. And clause 4D stipulates statement of total monetary value of construction work performed during the last 3 years under the irrigation department, bracket if any. It is also very pertinent to take note of the clause 4E, which stipulates experience in civil works in any other department under the government of Assam during the last 3 years, if any. This court further finds it very pertinent, taking into account the dispute involved, to take note of clause 4N, which refers to furnishing of a copy of the single work order having a minimum value as per clause 4 dot Roman 2 dot capital Roman 2 dot A bracket small Roman 2, which has been stipulated as mandatory. First, taking into consideration the reference made to clause 4 dot Roman 2 dot small a bracket Roman 2, it is relevant to take note of the said clause, which stipulates that the bidder oblique contractor should have at least one single similar nature work order under the government department of value not less than 30% of the package value of the tender. Which is stipulated to be mandatory. It is further pertinent to mention that the manner in which the completion report is to be submitted have also been mentioned in clause 4 Roman 2 capital dot A bracket Roman 3. It is further, it is at this stage, it is pertinent to mention that the petitioner duly submitted his or her, his tender, and taking into account the three parameters as laid down in clause 29 Roman 6, it would be relevant to take note of the details submitted by the petitioner vis-a-vis the respondent number 5. Insofar as annual turnover during the 3 previous financial years, the petitioner submitted a certificate issued providing the financial turnover. The financial turnover so provided in the said certificate is reproduced herein under page 97 of the same. It would exactly Hindi. This one. We don't need other things. First. Next. On the other hand, the respondent number 5 have provided a certificate from a chartered accountant in respect to his financial turnover. And the said being pertinent is reproduced herein under page 149 of the same. 149. Next. In respect to the second category, second aspect which is required to be taken into account is regards the higher value of single work order in similar nature of work. The petitioner had submitted a certificate. Where is that?
116, Lord, page
Huh?
100, page 116,
160.
116.
116. Which one?
All these, up to 8. lordship.
Single work is which one?
Single work is lordship at, serial number 1, improvement of canal system.
Had submitted a work done certificate issued by the executive engineer, Paneri Kolaigaon Division, in terms with clause 4 Roman 2 capital small a bracket Roman 3 of the instruction to the bidders. It is relevant to take note of that in terms with the said work done certificate issued on, what is the date?
22/9. 22, 22/9, 22.
Huh?
22/9/2020.
Are you sure? 22 or 23?
Home below is 22.
Down below is 22, 22/9/2020.
22/9/2022. It is seen that the petitioner had completed various works under the irrigation department, various similar works under the irrigation department. And a single work order and a single work order being of higher value amongst others is in reference to work order number PKD-I/W/1/2021-22/38 dated 28/12/2021 pertaining to improvement of canal system from Cheney CH 1200.00 M to 1565 M of LMC and constituent dot of 150 dia HP outlet is equals to 2 bracket 2 in words numbers at Mayak Khat FIS under SOPD for the year 2021-22 bracket GR dot NO dot Roman 11 bracket close of a value of rupees 74,97, 7, which is the value, highest value?
7,49,727, and next is 9,98,000.
No. This is too less. You have to go by this one. Number 7. Which one is that? You are with this 74 lakhs, na?
Yes, Lord.
This is number 7. This is of 2011.
2011. This is 7,65,000. $76 lakhs. 54,000.
I think you are going into this one, number 7. Isn't it? In respect to a number 7 to put to it. কি লিখিলে লাইনটো? No, itu na likhibo. Itu. I have submitted a work done certificate dated 22/9/2022. Pache? Pache. Yeah. Totaling to rupees 1,19,24,007. Full stop. In the said work done certificate, which is in terms with clause 4 Roman 2 small a bracket small Roman 3. The executive engineer Paneri Kalaigaon division, Kalaigaon, na? Irrigation Tongla had issued the said certificate. The petitioner lays emphasis on the following work as the single work order for higher value. The same is reproduced here in under number 7. Huh? Number 7 to Kalikut, page 160 note. On the other hand, the respondent number 5 have not produced any document pertaining to work done under the irrigation department. Rather, he produced certificates issued by the PWD department. Relating to construction of CC Block Road from Jalukbari, relating to the following work, the details of which is given here in under page 179. A2 quote kori, huh? A2.
78 also.
Huh?
78 also is there or something like
But this is what he is asking for, na? 178 is what? Notice to proceed with the work.
it also irrigate under PWD.
No, this is the work. This is the work done. Na? Page 179 is the work.
You just work done certificate.
This is the, we only require this one.
Work.
Okay. In respect to the third aspect, which pertains to equipments, the petitioner has provided the following details by way of an affidavit filed on 24th of February 2023, which is reproduced here in under page 130 in items, equipments, and manpower. It is 1 over 10. On the other hand, the respondent number 5 have provided the said equipments, his equipments, by way of an affidavit filed on 27th of February 2023, the details of which are herein under a page 163 and 164 of details. First, from the above equipments so provided by the petitioner vis-a-vis the respondent number 5, the equipments are similar. The equipment so mentioned, equipment so proposed to be used in the work are similar, are on the list of the equipment so to be used in the, so proposed to be used for the works are similar in nature, similar in quantity, in nature, and in quantity, except the fact that the petitioner has a vibrator and the respondent number 5 has $100 kudals. What is kudals? Spades, no? The Spuda, no, that is not that. That is Belsa. So I think spade. Spade is a Kudal, no? Spade. Bracket spade. Full stop. In the above perspective, comma, now let this court take into consideration that the petitioner along with the respondent number 5 and another were held to be technically qualified and their financial bids were opened by the respondent authorities. On 21/7/2023, it was found that the petitioner, comma, the respondent number 5 and another Sri Parimal Debnath had quoted the same amount, that is rupees 155,11,320 each. Full stop. Therefore, the petitioner, comma, the respondent number 5 as well as Sri Parimal Debnath were L1 bidders. However, without assigning any reasons in the said minutes, comma, the chairman, comma, council head of the department, he's the respondent, na? Number? The respondent number 2 allotted the work in favor of the respondent number 5 and pursuant thereto on 25/9/2023, the notice to proceed with the work was issued in favor of the respondent number 5. It is under such circumstances the present writ petition has been filed. The record reveals that this court, by an order dated 26/2/2024, issued notice, no notice, had passed an interim order, issued notice no, had passed an interim order, thereby staying the work order dated 25/9/2023, issued to the respondent number 5. Subsequent thereto, notice was issued and the interim order so passed was continued. Was notice issued? No notice.
It was issued.
Where is notice?
You can also customer service applicant respondent number 5. This service was taken on 16/02/2024.
No notice.
Service was taken.
All were permitted, but notice not issued. Subsequent thereto, the interim order continues thereafter. Full stop. It is pertinent to mention that the respondent number 5, the respondent numbers 1 to 4, no, respondent number 3 had filed an affidavit in opposition. The reasons were assigned for giving a preference to the respondent number 5 vis-a-vis the petitioner is on 2 counts, as would be seen at paragraph number 12 of the said affidavit in opposition. it is stated that the respondent number 5 had a higher single order value of rupees 81.99 lakhs compared to the petitioner of 74.54 lakhs. The second ground so mentioned is that the petitioner had failed to submit submitted two different lists of equipments which was not in conformity with each other and also not in the prescribed format. There is, however, no mention as to why the respondent number 5 was preferred vis-a-vis Sri Porimal Devnath, who was also the L1 bidder. In the backdrop of the above, this court have duly heard the learned counsels appearing on behalf of the parties and have carefully perused the materials on record. Next, decision, analysis, and determination. From the above segments of the present judgment, it will be seen that for the purpose when before taking up the issue as to whether the petitioner, the respondent authorities, more particularly the respondent number 2, have applied the provision of clause 29 Roman 6 in the proper perspective, this court finds it relevant to take note of the stand which have been taken by the respondent number 3 in his affidavit in opposition. First, the first stand so taken is that the petitioner single order higher value work was rupees 74.54 lakhs compared to the respondents who had completed a single work valued of rupees 81.99 lakhs. In the opinion of this court, the said parameter, the said reason, as the said reasons so assigned, do not appear to be sound on the basis of the contents, on the basis of the instruction to the bidders, and more particularly clause 4 Roman 1, capital Roman 1, and clause 4 capital Roman 2, A Roman 2, small Roman 2. Inasmuch as the single work is of work pertaining to similar nature, and this aspect of the matter have not been considered. It appears to have been considered by the respondent authorities. First, it is pertinent to mention that in clause 4 capital Roman 2 small a bracket Roman 2, read with clause 29 Roman 6, the single high value work order is of similar nature. And therefore, the respondent authorities were required to consider as to whether the work in question executed by the petitioner vis-a-vis the respondent number 5 were of similar nature. The next ground so taken for preferring the respondent number 5 as against the petitioner is that the petitioner have provided two different lists of equipments which was not in conformity with each other. First, it is pertinent to mention that the said ground appears to be an afterthought, inasmuch as the petitioner's bid was not rejected on technical grounds. Be that as it may, it appears from the list of equipment so quoted herein above as submitted by the petitioner as well as the respondent number 5 that the equipment so provided by the petitioner as well as the respondent number 5 were almost similar, except the fact that the petitioner has a vibrator. And on the other hand, the respondent number 5 has 100 spades. First, this code further finds it very pertinent to take note of that amongst the 3 parameters as set out in clause 29 Roman 6, one of the parameters is higher annual turnover. And from what has been mentioned herein above, what have been mentioned herein above, in the previous, in herein above, it would be seen that the petitioner's annual turnover far exceeds the respondent number 5. First, therefore, next, it appears that the preference so given by the respondent authorities, more particularly the respondent number 2, in favor of the respondent number 5, do not appear to be, and it appears to be arbitrary, unreasonable, unfair, as well as irrational. First, in that view of the matter, the instant writ petition stands disposed of with the following observations and directions. The minutes of the Financial Bid Evaluation Committee held on 21/7/2023, Roman 1 day, is set aside and quashed. The notice to proceed with the work dated 25/9/2023 in favor of the respondent number 5 is set aside and quashed. Number 3, the respondent herein are directed to reevaluate on the basis of the observations so made herein above and taking into account the materials so submitted by the petitioner, the respondent number 5, as well as the Sri Porimal Devnath, as to who would be entitled in terms with clause 29 Roman 6 to be awarded, to be entitled to the preference for being awarded the contract in question. The said exercise be completed within a period of 15 days from the date of the present order, present judgment, from the date, within 15 days from the date a certified copy of the instant judgment is submitted to the respondent number 2, number 3, number 4. This code further directs the respondent authorities to call for extending the validity of the bids so submitted by the petitioner, by the parties, that is the petitioner, comma, respondent number 5, as well as Sri Porimal Devnath, for the purpose of consideration of their case in terms with clause 29 Roman 6 of the IT. This I am giving, otherwise tomorrow they may say, why should they interpret? Better kitabkan ko. Better. Your case is on 42.
Yes. The case of reassessment. This proposed notice was issued, my lord.
I've heard you yesterday. He has also nothing to say.
Only the limitation part.
Only on the limitation.
Because
question. You
well,
can't
the
do.
process was initiated. Finally, my lord, culminated with an order. If you order in.
The process initiation has no relevance. It is the order which has to be passed. Heard Mr. R. Dubey, the learned counsel, appearing on behalf of the petitioner. Mr. B. Gogoi appears on behalf of the respondent numbers 1, 2, 3, 4, 5, 6, all the respondents.
Only thing, my lord, that may be recorded that my submission is in 12, it isn't initiated, order has been passed in 20. This is the con- that part.
Where's the order? Order of reassessment?
Yes, sir. Page 48.
Initial 39, my lord, then 5, 140.
The petitioner herein have assailed the order of reassessment done in terms with section 40 bracket 1 of the Assam Value Added Tax Act 2003, hereinafter referred to as the Act of 2003, on the ground that the said assessment or reassessment order is contrary to Section 40 bracket 2 of the Act of 2003. First, the materials on record shows that for the year 2007, that's 8 for the assessment year, na? Assessment year 2007, that's 8. Assessment was completed on 25/6/2012, isn't it?
Financial year. What I say is financial year 2007.
2007, that's 8.
That is the financial year.
No. Financial year 2007, that's 8. Assessment year is only in income tax. Assessment was completed. Where is that?
Page 34.
Page?
This is the assessment order. Page 33 is the type one.
Assessment was completed. Under Section 9(2) of the Central Sales Tax Act, read with Section 86 of the Act of 2003. On, what is the date?
25/6/2012.
25/6/2012. In terms with the said assessment order, comma, the only amount payable was rupees 250. And this was duly informed to the petitioner by a notice of demand directing the petitioner to deposit the said amount on 1/7/2012. The petitioner accordingly deposited the said amount via the challan on 21/8/2012. The record further reveals that a show cause notice was issued on 3/10/2012. Intimating the petitioner to show cause in writing as to why the claim of 6(2) sales under the Central Sales Tax Act should not be rejected, and escape turnover of rupees 30,97,920 shall not be assessed to tax at 4% under Section 40 of the Act of 2003. It is pertinent to mention that in the said show cause notice, there was inadvertently mentioned as financial year 2009-10, which was for the year 2007 and 8, and the said aspect is not disputed. It is the further case of the petitioner that the representatives of the petitioner appeared before the assessing officer and explained before the concerned assessing officer. Is the assistant commissioner is the assessing officer? That is the Assistant Commissioner of Taxes, Guwahati Unit A, and informed that there was no escapement of turnover as alleged in the notice dated 3/10/2012. Full-stop. The said proceeding thereafter did not proceed. As would appear from the records itself. And it was only on 14/11/2022 the Superintendent of Taxes, Unit A, issued another show cause notice referring to the show cause notice dated 3/10/2012 and asking the petitioner to show cause as to why assessment under Section 40 of the Act of 2003 should not be completed, should not be carried out. The petitioner submitted a reply on merits as well as taking into account the point of limitation as stipulated in Section 40(2) of the Act of 2003. Pursuant thereto, on 22/11/2022, the assessment order was passed, whereby
He submitted a reply later on, by
Because
the
the
time
expert
the
note.
assessment order was not passed.
Huh?
Was submitted on 26, your lordship sees page 46.
Oh,
26,
26
11,
November. Okay.
expert.
Yeah.
Because somebody had expired in the family, the petitioner.
I call it
represented to
and
go ahead
issue
to
the so cause notice on 14/11/2022, asking the petitioner to submit issue the by making a reference to the communication dated 30 so cause notice dated 3/10/2012 and asking as to why and to show cause in writing as to why action should not be taken to complete the assessment under Section 40 of the Act of 2003. The petitioner thereupon, on 22/11/2022, the assessment order was passed, whereby it was held that the petitioner was liable to pay an amount of rupees 4,55,155. And in consequence thereof, a notice of demand was issued, thereby directing the petitioner to deposit the said amount on 21/12 on or before 21/12/2022. It is relevant to take note of that the petitioner, subsequent to the assessment order being passed on 22/11/2022 and the notice of demand being issued, submitted a reply on 26/11/2022. It is under such circumstances the present writ petition has been filed. The record reveals that pursuant to the filing of the instant writ petition, this court, by an order dated 7/2/2025, issued notice and stayed the operation of the assessment order dated 22/11/2022, semicolon, the notice of demand dated 22/11/2022, as well as the certificates dated 7/9/2024 and the demand notice dated 7/9/2024 until further orders. The record reveals that pursuant thereto, comma, the respondent number 2 filed an affidavit in opposition, wherein the impugned assessment order dated 22/11/2022 was defended on the ground that the same was within time in view of the fact that the notice was issued, so-called notice was issued on 3/10/2012. And the petitioner was given adequate time to be heard, adequate opportunity in that regard. Taking into account that the instant writ petition, the issue involved in the instant writ petition is solely on the question of limitation as stipulated in clause 40 bracket 2, section 40 bracket 2 of the Act of 2003. This court have duly heard the learned counsel appearing on behalf of the petitioner and heard Mr. R. Dupay, the learned counsel appearing on behalf of the petitioner, and Mr. B. Gogoi, the learned counsel appearing on behalf of the respondents. From the determination and an analysis and determination. From the materials on record, from the pleadings of the parties, and the materials on record, the materials on record, and the submissions so made by the learned counsels appearing on behalf of the parties, the issue arises, the issue which requires consideration is as to whether the impugned assessment order and the consequences demands so made on the basis thereof is within the period of limitation as stipulated in section 40 bracket 2 of the Act of 2003. First, taking into account the said aspect, this court finds it relevant to reproduce subsection 2 of section 40 of the Act of 2003 herein under. From a perusal of the above quoted provision, it would be seen that no assessment and reassessments shall be made under subsection 1 after the expiry of 8 years from the end of the year in respect of which or part of which the tax is assessable. From a perusal of the said provision, it does not mention anything about initiation of assessment or reassessment proceedings. Rather, it stipulates that no order of assessment or reassessment would be passed after the expiry of 8 years from the end of the year in respect of which a part of which the tax is assessable. In respect of which or part of which the tax is assessable. First, in the instant case, the assessment is for the financial year 2007-8. The period ends on 31st of March 2008, isn't it?
Yes.
First. the period within which an assessment or reassessment can be done in terms with subsection 1 of section 40 in respect to the present dispute, in respect to the financial year 2007 and 8 would have been on or before 31/3/2016. First, in the instant case, the assessment order was passed on 22/11/2022, and the same is apparently barred under subsection 2 of section 40 of the Act of 2003. Consequently, this court, therefore, disposes of the instant writ petition with the following observations and directions. Number 1, the impugned assessment order dated 22/11/2022 is set aside and quashed. Number 2, the impugned notice of demand dated 22/11/2022. Assessment order for the financial year 2007 and 8. Dated 22/11/2022 is set aside and quashed. The impugned notice of demand dated 22/11/2022 for the financial year 2007 and 8 is set aside and quashed. Number 3, the proceedings for recovery sought to be made by the notice to the certificate, by the Bakizai proceedings so initiated, enclosed as Annexure 21 and 21, is set aside and quashed. There shall be no order for costs. Records? What is the petitioner's name? Biju Biswas. Biju Biswas is where? Biju Biswas. I Biju Biswas so and so that I have read the notice inviting tender dated 18/3/2025 posted by so and so and the terms and attachments that I fully understood the first inspector. What is the date of the notice inviting tender?
17. 17.
17?
17th of March. They've written 18th of March.
Here you have written 18. One has written 18. The other fellow has written 3/4. What is his
3/4
name?
was the last date of submission.
Yomen Namodas. He has written 3/4. I read the notice inviting tender dated 3/4/2025 plotted by so and so. Then the other Prasanna Bormon. Was he right?
It's a flag mark.
Three, four. Why they are confused with 3/4?
My lord, actually, what happens, my lord, they are from, not from Guwahati, and my lord, this, state, they hear it, and my lord, they prepared all the affidavits there, and thereafter they come to Guwahati, my lord, for fighting.
No, no, by why they are mentioning about 3-4? Because all three are 3-4.
And
You are the nearest.
Maybe.
Yes, all are 3-4. Why? Was any other notice inviting tender issue?
No,
3-4.
no, that's the only notice. Therefore, my lord, my submission will be mentioning of the wrong date, my lord, does not.
No. Here there is an undertaking. As per the, you are undertaking the terms as per the notice inviting tender. So then,
Curative defect.
how do you do that?
This does not change.
Means that you are not undertaking that notice inviting tender, which is not in existence.
My lord, my submission. Five tenders have given prejudice, number one.
No, it is not the question of prejudice. It is the question is tomorrow, if it is given to you, that undertaking which you have given in your affidavit would not hold because you are giving in respect to a tender notice which is not in existence.
My lord, assuming, my lord, what your lordship is said is correct, my lord. In a particular, my lord, the fishery, this has been done, my lord, in respect of Takara fishery. For that, my lord.
Your bill is what one?
all bill,
Dokora.
Takara.
All Dokora bill.
all the traffic.
Now they have cancelled the entire, my lord, 22. Because the NIT contained, my lord, 22 fisheries.
We are not concerned. We are only concerned with Dokora bill.
We are, my lord.
No, they have done it for a year, but if they have done anything about others, then it is a matter for the division bench to consider. No, not
Secondly,
because of that. It
the
will be a
retender
public
also.
interest litigation.
In the retender also, my lord.
My only query that is, they know that they are the first bidder, highest bidder. That is the very much.
Wait. Another interesting thing, Mr. Chaudhary, is this. Very interesting thing.
I think they have.
This is by this Moinuddin Ahmed.
On
This is from Dhubri, huh? Who has meant, in your case is Moinuddin Ahmed is the notary. And the advocate is Momzud Shaman. Let us see why this mistake has been committed. This is by T.B. Jaswim, Notary Public. These are no dates. All 5 other 4 are by the same advocate. Your advocate is only the different. Who knows it to be 18C nearby? But is there no date mentioned in the notice? Let us see.
Yes, my lord, it's written. In the NIT is written.
NIT, why
NIT
is
is
it
what you
mentioned
find
like
at my lord, page 25 is the vernacular.
38. No.
No, it is mentioned clearly 17.3.
Yes, 73.
Then- And the requirement is the filing of the affidavit is where?
My lord, this confusion may be because of the fact that, my lord, if your lordship sees the second paragraph, সরকারপল্লী হইতে নিবিদার প্রমাণপত্র, then your lordship will find নিবিদা উত্তর তিনি 2025 ইংরাজির পড়া 3/4/2025 দিনের 2 বছরে গ্রহণ করা হবো. They have taken, my lord, my lawyer has taken 18
No,
into
where is the requirement for filing an affidavit? Why do you have to file an affidavit?
my lord, in the NIT, my lord, NIT is very short. And my lord, the terms and conditions are guided by, my lord, there is a different kind of guidelines.
May I take the one
Where
envelope,
the-
one envelope. Inside the envelope, there is an.
Hmm? Where is the requirement of filing an affidavit?
This is what I have.
This is only, but the main problem is you have not included this, na?
NIT is not being enforced.
NOT is not here. Without the NIT, how? We don't know that you require to file an affidavit. No. This is a notice, but what are the terms?
Terms and conditions are guided by this one.
They have signed it and
Where does it say that there is an affidavit required?
My lord, that your lordship will find, my lord, clause
25, Roman 5.
yes, on Roman 5, বাকি যে 3 বছর আমার
Because here he says, I have read the notice inviting tender and the terms and conditions attached therewith for settlement. Where are the terms and conditions attached? Attached means you, what does it mention on?
my lord, terms and clause, মানে clause 5, does not, my lord, speak of an affidavit. I don't get it, my lord. I checked it before, your lord.
Show me that.
was not a NIT lottery. Last part, lordship. For individual tenant, last part. Page number 13, lord.
Is number 13. Ah.
12 and this is for
No,
individual.
no. This affidavit is required is where?
That is not stated in the, my,
That is,
clause 5, there is no statement whether that.
No, there will be somewhere. No, what is this? This is the document.
this is the NIT they have signed while filing the, this is the document, this is the NIT. Which is, they have not annexed it. This is in the bottom, there is a signature by the petitioner.
There will be somewhere mentioned.
Yes, lordship, I skipped it.
Yeah. Kindly come to 6, 8, page 4.
Yes, lordship.
So this is the thing, non-judicial stamp paper.
Yes, sir.
This is the,
They have signed it, he has signed it.
huh?
Biju Vishwas has signed it in the bottom.
Ah. No, the requirement of filing the affidavit
Yes.
is this. নিবিড়িৰ লগত সংলগ্ন কৰি দিয়া শপত
নামখন 100 টকীয়া দলিলত পূৰণ কৰি দাখিল কৰিব লাগে।
কৰি দাখিল কৰিব লাগিব। So this is the affidavit and this is the document which is required to be submitted.
Yes.
They have submitted a wrong affidavit. This one. Notice inviting tender dated, they have made it wrongly. The rate in the tender for settlement of we are taking into consideration the local conditions and water. I shall not claim in remission or the reduction of revenue, nor shall be responsible to the Assam for not anything. Okay. But heard Mr. M.K. Chaudhary, the learned
the-
senior. Yes,
Sorry to worship, this message is the good.
Second NIT, my lord, was issued, I mean, the call is retender, the cancellation was not there, that was not publicly notified. And my lord, that the time limit has not been, my lord, stipulated that debarred me for participating in the second time.
but what have you mentioned in why you have not participated?
That I, this has not been cancelled, so this should be considered.
Huh?
It was not my case, my lord, when I filed the petition, was that, my lord, the tender number 2 of 2025, that has not been cancelled, so that should be finalized. And according to the requirement, my lord, they had to open the financial bid and the price bid on the same day. Now, after filing of the petition, my lord, this order has come, so the reason for cancellation has been given. Now, that is dated, my lord, 23rd of June.
No, Lordship.
Whether, my lord,
not-
that is there, please let me complete. Why do you get excited? Vote is in your favor.
You are referring to clause 1.3 of the
Well, that we-
guidelines of the
yes, my
terms
lord,
and
that was
conditions
referred
of
to
the
in
ABC.
the
What is that?
The old one was provided to me, madam.
Yes, only old one, not this one, not this NIT he was holding it.
Then how does it have a,
will
that is where it is
Even-
15 days.
Because it's a two-bit system, Lordship.
2.3.
Here, my learned senior was briefed that, it was a one single bit system. Actually, it's a two-bit system, clause 4, Lordship.
Oh.
NIT. this one.
No, first, before that, your lordship will see clause 2.3, madam. 2.3 of this.
This one earlier one. This one.
No, new one.
No, not new one, your one, not the new one, Lordship.
Now here also it is there, clause 2.3.
Yes, yes. Not, I'm not holding the new one, new NIT, new document.
This one,
This one is old.
but this one,
Yes,
this is the new one.
recently one.
So here clause 2.3,
Yes. this is there.
15 days.
The 15 days is there, Lordship. It was being fulfilled, Lordship, while this NIT was done, Lordship.
The second one,
First one.
the first one is okay, second one.
Second one, actually, I don't know whether these 15 days are there or not. Maybe 13 days. That was not under challenge, Lordship. That second one regarding that, but they have not participated in that second.
How, if they participate, then they cannot challenge that clause. Can they challenge that? Well, then they lose their locus
But
on
if
challenging.
The second one, if there, I don't know whether it is, whether 13 days is written or
No,
not.
that is there in the NIT, my lord, that notice has been given, your worship.
No, in the new one, whether it is 15 days or 13 days, I don't know, Lordship.
That is
I-
there on the record, in the.
But here in the earlier one, it was 15 days.
No, no, we are not concerned with the earlier one.
Page
That
30.
present one, which,
The present one,
present one is 15 days. 15 days was already complied.
Page
so
38.
you are saying about the new one.
They were saying about the new one, which they have not challenged. Actually, the matter is, Lordship, become,
Now, are you saying that there is a change in this?
I don't know, Lordship, that part I don't know. That part. In the next one, next retender notice,
নিবিদা জাননী নিবিদা দাখিল হম
normally it won't say.
পোন্ধৰ দিবা 15 দিনৰ আগতে প্ৰকাশ কৰা হ'ব কমেও means minimum.
Minimum 15 days.
And then this I don't think is changed.
it may not change lordship. In that case, lordship, if lordship can interfere in the next tender, lordship, but it is the present one is a earlier one earlier tender where all the bidders.
No, here I'm not challenging, I'm not interfering with this one. I'm saying that the retender process is okay.
Yes.
But the question is, could you have given this without 15 days? Because you made it on 26, no?
Yes.
Yes, my lord,
And
26
26 is only 4 days.
is 38, my lord.
26, 27, 28, 29, 30. 1, 2, 3, 4, 5, 6, 7, 8. 13 days.
In fact, my lord,
13
there,
days,
your
yes.
lordship's one judgment there, my lord, the terminal days are also to be excluded, my lord.
No, that is for that one, na? Panchayat.
Panchayat.
Panchayat is different here.
We can consider that part. If it is wrong, lordship, I don't know. I can advise.
No,
them.
no, the question is like this. You see, the challenge so made is regards your action for retendering. No, he cannot challenge. That is gone. Only aspect is whether this was done in 15 days. Because now what happens? There are two options. If it is not done in 15 days and if this was the term on which you have done,
Yes, Lord.
then in that regard, there are two options. Either give him the participation, but if I give him only the participation, he has a still march because now, as of now in the market, he must have come to know who has quoted how much.
They won't know, Lord, because
You will know. You will know. This one. You will know. And thereby this will prejudice the others. One. Secondly, this would not only affect him, but would affect others also,
yes,
who would have otherwise be entitled to, who could have. So therefore, I may have to go for asking you to go for a fresh tender in respect to this. Now, this is there is the judgment of Court of Justice B.K. Sharma, Jiten Kolita, if I remember. This was the issue. Following Monarch is one judgment on that, if I remember. Although I don't do this type of matters much, but I think Monarch is the judgment.
Subsequent tender is under challenge in this regulation.
Understood. So the question is, challenging is only on this 15 days.
Right.
And thereby asking you to go for a fresh tender. That would be the best way out. Yeah, but anyway, let me have a look at the Monarch, because Monarch is the judgment on this point. Monarch infrastructure as to who can challenge and how not. This Monarch infrastructure versus Ulasnagar. Yes, I remember that. Yes, 2005 SEC. Here it was a case that one of the tender condition was deleted without notice. And thereby it affected the others. So that is why I'm saying here, notice inviting tender for appointment of agents for collection of octroi subject to the terms and conditions. One of the conditions of eligibility deleted after the expiry of the time limit for submission of tenders, but before opening of thereof. In such circumstance, award of contract to a tenderer who at the time of submission did not satisfy the said condition rightly set aside by the High Court. High Court also directed to, yeah. So this is how it is. So here, the moment I allow him to participate, thereby I am affecting the rights of others who would have otherwise been able to participate.
yes.
I am giving him the right.
But in this case, lordship, if lordship, without hearing the other who had participated in the tender.
They have not, they have only participated.
Yes.
You have not given them any right. So
We have
therefore,
not
no.
opened Financial bid also.
Huh?
We have not opened the financial.
So therefore, nothing is there. No right has been created in their favor. So now, therefore, if I allow him now to participate, Like he knows today that he is the lowest bidder.
Highest bidder.
He's the highest bidder. He will know this thing. The same thing he will know. Who has quoted how much?
Sorry, even we don't know how much,
Huh?
even we don't
No,
know.
you don't know. In earlier tender, you also you don't know. But he knows that he thinks that he's the highest bidder.
Yes, Lord, it's a very interesting point.
So therefore, the best option is allowing the fresh tender. Fresh tender to do it. I think this is a better option than to stop all this thing. Keeping this matter pending out here is not going to help you out. But otherwise, the retender process goes. Rightly. Huh?
They retendered 22 all fisheries. Other fisheries should not be affected by this.
Yes.
There are as many as 22 fisheries visible in my notify.
Now we are only concerned out here with that Dokora bill, huh? I'm not concerned with others. But this will affect others also. Don't you think that? Because if I hold it. But here the petitioner herein, that is why I'm saying about monarch infrastructure comes into the being. Because that person,
Oh, then we have to cancel all.
no. That person only came.
Give me 2 minutes, Lord, whether it is 13 days, if they have written in the NIT. 2 minutes, Lord.
Okay. Chalo, let us take up another matter.
Who is there, my lord?
New NIT.
No, this is not here. It is in here, it is this.
Yes, my.
But this was the earlier one.
No, it's not his age, Lord. They have signed it.
No, this is the earlier one. In respect of which you were the highest bidder.
Could not be because the signature of my client appears in the form.
Yes.
There should
Or
not be
you
one
are
in the
you are the highest bidder in this tender, which you could learn in the marketplace. But he is saying about what about the next tender? You have the records. We pick it up tomorrow as the first item. Well, look at it. List the matter tomorrow. The first item, Mr. P.K. Sharma.
Please, Sharma. Please, Sharma.
P. Sharma had produced the records. Full stop. This court further would consider the matter today, comma, the records so produced has also been returned. List the matter tomorrow at 2 p.m. Tomorrow there is no reference.
Hello. Reference is correct there.
The reference is on Thursday 1 and Friday 1. Thursday 1 person, Friday 2 persons.
Then my lord, Monday again.
Huh?
Monday again. My lord.
Monday there is no reference.
My lord. Swearing in.
Monday at 10 o'clock, I think the swearing in is there at Kalaketra, and then the court will sit at 11. That is to my knowledge as of I don't know much. Itu kali itu. Anything?
Lordship, what I understood is that Lordship, 5.3, read with 5A, capital A, 3.2, capital A 3.2B says that exceeding connected load authorized by the supplier. So 5.3 says that once the connected load is, it says that at any time after the supply of energy has been commenced. So the moment when the energy is supplied at the very first time, and if the connected load he wants to increase, then he has to file an application before that. And therefore,
No, Mr. Counsel. You see, apart from all this thing,
Lordship,
this is the finding of fact.
Lordship, regarding the finding of fact,
Unless you show that there is a perversity.
yes, the appellate authority decided that at the time of inspection, the representative of the respondent number 1.
Kindly come from page 81. Let us read from page 81. Having gone through the documents, record of energy consumption and maximum demand, etc., and the arguments hearing so and so. Let us read it. Read.
Having gone through the documents, records of energy consumption and maximum demand, etc., the arguments during hearing, it is observed that the Chief Vigilance Officer of Irrigation conducted a vigilance operation on the basis of the letter written to the DCM Vigilance Wing, AACP by 1 Sri Gokul Kolita of Vidyanpura, Sri Kolita alleged that Sri Anup Poddar, the owner of the said industry, manipulated the actual connected load by removing the detailed plate specification plates of the motors so that the connected load is underrated and monthly fixed charge is reduced. But while going through the inspection report of the executive engineer of the vigilance team, who is the only authorized assessing officer of the
Mr. Roy, just 1 minute. Is this the elder Poddar or the younger one?
Is the
There are two Poddars, no?
three.
The brother, the
Anup
one who has
Anand,
that
Anup
Poddar
Anand.
Mahindra one?
Yes. He is
Oh.
also Anup Poddar,
Anand Poddar.
dealer of Toyota.
Uh,
Showroom is
here, this Anand Poddar is not here, na? In this
Anand
matter?
Poddar is
And so he is the partner.
Anand Poddar. Oh, then I won't take it up. I know because he used to be my client. Anup Poddar was not my client.
Anup Poddar, dealer of Maruti vehicle.
He's Maruti.
Anand is
This
dealer of
is Toyota and Mahindra. And Anup Poddar. Because
young-
I remember this Poddar rubber industry. At that point of time, this Poddar rubber, then it went to Anand Poddar.
Yes.
So therefore, Anand Poddar is the person who filed the affidavit. No, I
there
don't
was
think.
dispute between three brothers, then arbitrator award was there.
Better I don't take up the matter. I know these people. Chalo. Okay. List the matter before any other bench.
This is a challenge against the order of the labor code, thereby reinstating along with back wages to the workmen. The award is at page 26. Yeah, to summarize the matter, what has happened here is
You are getting 17B.
Manoj, so far as the client is concerned, I have no connection with long time. I tried calling up for instructions, Miller.
No. Are you getting 17B? No.
No.
Last round wages?
No,
what he is saying is that he doesn't have the connection
No
or
connection with
communication. with
I'm not on that.
no, sir.
I'm asking when there is a question of when there is a reinstatement order, then normally he has to get the benefit of 17B. You have not
Only
got
if he
it.
files an affidavit saying he's not gainfully employed, then it is paid. Whether he has not filed an affidavit.
No. He has to get this benefit. Anyways,
An affidavit that
hello, we give him all the benefits later on. Now tell me, what is your case?
case that the management is making out the case by saying that the particular workman was never a regular employee and he was a casual employee who had worked intermittently in this particular Asiatic Ocean that company from 97 to 2000. And it was only a contractual employee, and therefore when the purpose of the contract was over, then it was automatically retrenched. He was retrenched. Now the case that the management brings up is saying that
Yes.
Our case was that since he was working intermittently, he could not have completed 240 days during that tenure. For continuous service, he has to be there for 240 days.
What evidence you give?
We didn't give any evidence,
Then-
but I would like to place a judgment which says the owners.
You should have given evidence.
No, the owners, I am placing the argument that I'm making is on the basis of a judgment, which says the onus to prove that the workman had worked continuously for 240 days is on him. So if the onus was on him, so it was basically therefore for him to prove that he was, because we had disputed that. He stated that he worked from 1994. We disputed that by saying that in the attendance register, or for that matter, the ESI contributions, his name is not there. That has also been a finding by the labor court also. The labor court, however, says that even though the finding is there, it's not that his name doesn't figure, but still there is no evidence from our side to dispute his thereafter his contribution. Well, we have said from 97, 99 he worked, but the ground that we took is intermittently. There was therefore no continuous service. There was no continuous service.
Record.
Now, the ground would be if he had worked for 240 days.
Record.
If you had worked for 240 days, then he gets the benefit of 25F, which says that notice has to be given. So therefore, our argument was that it was for him to prove that he had worked continuously for 240 days. And had he,
How will you prove? All the documents are with you.
otherwise, we have produced the attendance register, the ESI contributions and everything.
Huh?
This, Lordship will see the exhibits,
Huh.
the attendance register, as
Huh.
well as the ESI contributions.
Why there was earlier petition?
There was a petition, the matter was remanded back there. There was an award that went against us. We gave it to the honorable court. It was
Why was it remanded?
remanded on. It is
When
there.
when
order
the
is there.
workman has produced the appointment, it was incumbent on the part of the management to prove the same to be. Consider the submission made by the learned counsel and have also perused the material and records, including the reports received from perusal. What is found is that during the period, name of the did not appear in the attendance and also the document relating to your set. It was on that ground the management and another particular appointment was issued by the earlier officer and the two after committing. Considering that in my opinion the matter requires reconsideration and if any person may be allowed to use an excessive. That order of the workman.
Case 23, the order is.
You have not taken a single averment that he has not worked for 240 days in your thing, in your cross-examination.
Cross and was not
If it
there.
is not based on that thing, why should we to look into that in a tertiary jurisdiction?
Cross
I've looked into it. Doesn't take so much
case
time.
44.
This is in English. Required here, I've looked into the cross-examination. I was intermittently engaged as scheduled under the management. It is not a fact that Bhutan so and so are different companies. It is not a fact the management remains closed on a Sunday. Exhibit A was issued on Sunday. It is not a fact that Exhibit A is fraudulent. Now, let us see Exhibit A. List of exhibits.
Difficult to prove otherwise. It's a appointment letter of 1994, which we say was issued by the then manager on a Sunday.
And the
therefore-
Sunday,
and
Monday
therefore
is
we-
not the
I
question. The
understand.
question is whether that your stand is that he was not working. He was not working. But did you prove that he was not working? Yeah,
This is
no.
placed the judgment.
With reference to your application dated and the subsequent interview with us, we are pleased to appoint you as the assistant to the report. That you will be paid a monthly salary of 1,200 rupees in the grade of so and so, that you will be paid allowances so and so. Then this is being done. Then SK Roy purchase. Who is SK Roy? SK Roy?
Sanjay Ghosh. SK Chaudhary, I think.
SK Roy. Payment of so and so. Of bills against supply of so and so. SK Roy. Manager collection of outstation check. Yeah, Sanjay Ghosh.
Sanjay Ghosh is the workman.
Since we are in urgent need of funds, we would like to request you to authorize Sri Sanjay Ghosh, whose specimen signature is attached herewith, for carrying out or doing the necessary payment advice from your bank. We have totally today deposited a check of rupees 2 and so in favor of 20. So we are in urgent need of funds. We would like to request you to authorize our Sanjay Ghosh, being one of the participants in the aforementioned tender, we would like to request you to your good self to allow Sanjay Ghosh, his specimen signature is demand, and to witness the tender opening on our behalf. Thank goodness. You know, documents which shows that you have appointed him. Office of the Labor Commissioner, Asiatic so and so could not verify it in the time of yes, election. Probation period 11 to years, salary. Hectare, 1 million. Yeah. What are these other documents, the courier service?
Used to take things under the authorities of the petitioner,
Hmm?
Workmen used to take things or take charge of materials, things under the authority of the petitioner. And to that extent, the communication would reflect that he was in service of the petition. But to the entire proceedings and cross-examinations, no question was put and nothing is on record to suggest remotely the case projected that he is not in service. Rather, the entire case was that.
No, no, why are these, this SK Chaudhary, who is the branch manager? He appointed
SK
on
Roy.
11.
Chaudhary.
So
He was
Ah,
not then
this
branch
is how it
manager.
is relevant. Wait. Exhibit A. 11 September 1994. See? He was working?
He was working, paragraph 9 of the judgment. Lordship was, he was.
No, no,
working
no,
on
no, no, no,
it.
these are not relevant, Mr. Sharma. These are all these documents which have been issued from Asiatic Oxygen Acetylene Co. Limited by SK Chaudhary, branch manager, on various dates, even on 6/10/2024. All these documents have been issued. And now you are saying that he's not working. This is your written statement. How is it possible? That is why these documents are relevant. Yeah, I was thinking why these documents are relevant. Hello. Then register for this. Register for this. What is this register? Possession certificate. Okay. You were appointed when?
That was 11th of September 1994.
When you are taking that plea, you have to prove it. Let us see your written statement. When is the attendance register? SK Chaudhary was working? No. This SK Chaudhary was working all along.
Yes. No.
Then, huh?
Case already, as per, he was there in the company for some time, and in 1999, then he has left the company.
But we are concerned with the 1994 appointment order. Then, he was working.
At that point of 1994, yes, he was working.
He was working.
When his appointment order was passed.
94.
Then,
That is what I said. We have not been able to successfully dispute that. I said that.
no, no, the
However,
question
the
is,
ground taken by
no,
the
the
management-
question is, have you raised any FIR? Because when did the dispute arose? Or did you terminate? Let's see your termination order. Where's your termination order?
There's no-
Then what did you have? Huh?
He asked me to leave me.
There is no termination order.
There's a termination. order.
No termination.
Verbally 30th of December 1999.
Hmm.
The joint branch manager, Mr. A.K. Chakraborty, verbally informed that the services are no longer required.
During the pendency of
And
the
without
reference
notice, I
file,
have
the
to-
following documents, yeah, exhibit 1, file containing letters of management, 2, so and so, so and so, so and so. Let us see the document. Where is the affidavit?
Paragraph 2 of our written statement, we have stated
Very humble of Sanjay Ghosh. Sanjay Ghosh, what do you say?
Page 44, I think that Sanjay Ghosh process.
What? Ah. Yeah, what do you say? That the workman was never employed by the management permanently with effect from 11/9/1994. As alleged, of course, the workman was employed on casual basis by the management intermittently from the middle part of 1997, and when the purpose for which he was employed became over, his employment automatically stood terminated with effect from 31/12/99, and all his emoluments were paid to him. Yes, that is what. Then you say at the relevant time, the alleged so and so where was functioning as the manager of the management company. Said went on leave on so and did not join his duty for a considerable long period, and due to some differences with the company, he resigned from the services of the company in November, and present incumbent was promoted as the joint branch manager. On getting the conciliation notice, what is it? No. Did you file an FIR?
So it's not
A.K. Chakraborty was a joint branch manager.
Huh?
A.K. Chakraborty was a joint branch manager.
Huh.
I was appointed by S.K. Chaudhary. I was appointed by S.K. Chaudhary, the branch manager, 94. Subsequently, 1999, the joint branch manager, he verbally dismissed me or terminated me from service without notice.
No, that is okay. I'm not on that. But where is your plea that he doesn't come within 240 days?
that written statement, paragraph 2 is what I
No,
have.
paragraph 2 also you categorically say that 200 and
The word
he works casually.
service.
You cannot develop unless something is brought.
Because industrial dispute
No,
act.
you are raising this. No, Mr. Counsel, you are raising this issue for the first time here. Because this is your written statement is not clear on that aspect. That he would not fall within the ambit of the casual labor, casual that he doesn't have 240 days, so he would not be a workman. Your written statement, there is no evidence adduced to that effect. Neither in his cross-examination you put that question to him. If you have not done, how can you raise this issue here? No, so today I've not dismissed so much without cost. So 1 lakh? Cost of 1 lakh? Of which 50,000? But I'm surprised why 17B is not.
That's what I also tried to contact the client this morning. I called up.
A very sad state.
My second leave of argument is on the quantum, of the relief that has been granted. Reinstatement, yes, reinstatement is been given.
Now the reinstatement not possible.
So it's possible, he's only 51 years old.
How do you know?
Because at the time when he was appointed, 94, he was 20 years. There's a one document that says he's 20 years. So if I counted from 1994 as 20 years, now he is 51 years old.
But you would say there is no establishment, I presume.
Huh?
Reinstatement.
There's another
Yeah,
aspect
that's
is that the industry is otherwise closed. We'll also will see.
He's saying for reinstatement at the same time, same rate he
No,
says
the
the establishment is not
the
there.
company survives, but then these units, as is where he was working, is closed. Phase 15, 2005 only, the units that he was working.
Age?
Phase 15 of the repetition. It has been declared by the BFR as the company is sick company, and therefore, if your lordship will come to page 16, the second last paragraph,
Where?
Page 16, second last paragraph, under the circumstances, page 16.
Ah.
Under the circumstances, the management has no other alternative but to declare closure of the Tinsukia factory and its depot at Babu Bakar with effect from 39. So he was working in that particular unit. The notice of closure.
So the question of reinstatement does not arise.
Company survives. Can take an instruction on that aspect also. But yes, that is the fact that the company survives, but the unit where he was working was closed by way of a notice of closure because the company has been declared by the BFI as sick industry on 27th.
The Sikh industry, has it been, is it, the company is a Sikh industry?
Yes.
But after that Sikh, it is no longer Sikh. This is in 2005.
And the
Now,
unit is
as
closed.
of now, something must be there.
Take some instructions on that.
No,
Lordship,
it
as to
has
how-
to remain. Because
Company survives,
if I
sir.
understand as per the Sikha, at that point of time, you cannot further proceed with it.
Yes.
But thereupon, there has to be some arrangement or memorandum, what is the term used? Arrangements. This is called arrangement. Some arrangement has to be made, which is similar to 394 of the Companies Act. So in terms with that, you have to do this. Now, if you have not done this, means then if nothing happens, then it will lead to what you call liquidation. It has not gone into
So company
liquidation.
survives. My instruction is company survives.
Otherwise, you would not have been
Yes,
appearing.
exactly. I was worried about that in the morning. I asked him if the company survives or not. He said yes.
No, I asked the same question last evening. He said they'll be appearing in the.
So if he is appearing, then it has not gone into liquidation.
Hopefully.
And with Mr. Sharma appearing. So the question is now, if you can't reinstate him now, if that company is not there, then the question is, you have to take it up. How you do it is a different thing. But I am in 226.
So the relief
I would
plan-
not interfere. I would not exercise my sorcery. Then the provision, which provision is there, where the directors can be sent to jail? There is one provision out there, no? Hey, industrial dispute connection. There is a good provision by which you can send the director to jail. Okay. Industrial dispute.
instructions on this because I think it will be reinstated because
You take your instruction that you pay all the back wages and all.
on that aspect of back wages. if I
Back
may
wages
submit-
and all, and you enter into some compromise with him. That is the instruction in which he is. Otherwise, there is no instruction. There is a long dispute out there. The unfortunate, first of all, he should have been getting the, when it is a case of reinstatement, it is a norm, 17B. And Mr. Sharma, you also know,
Yes, but then he has to file.
we also know about the certificate, whether he has done or not, that is immaterial. It has been done away. Yes, at one point of time that was there where he need to file an application, but now there's no. Question of filing application and all these things has gone. Normally he is entitled to. This is as per the
Otherwise-
statute.
Last drawn wages is the.
As on wages, he should have been paid. Where in any case a labor court or the Limestone Tribunal by its award the direct reinstatement of Iman and the employer prepares any proceeding against such the High Court or the Supreme Court, the employer shall be liable to pay during the period of wages of such proceeding the High Court full last drawn and inclusive of so and so if the workman has not been employed in India, provided where it is proved to the satisfaction. The proof that the burden is on you. There are many judgments on this. The burden
then-
is on you.
And if it by such workman has to be filed to that effect. That's the last line. of
Where is
7.
it?
The last line of 17B.
Have not been employed in any establishment during
the
the
period
and an
by such
affidavit
workman.
by such has been filed to that effect in the court.
That's true. So normally, it's fine. It's not disputed by the other side, the last drawn wages are paid, but an affidavit never came from his side. So I think the management therefore did not pay. The lordship will kindly, sometimes I did not have an occasion to talk to the company, very honestly speaking. Let me just find out as to whether he can be reinstated and where and all those aspects. Because reinstatement, honestly speaking, reinstatement part I cannot object. That's why I said successfully we have not
Wait,
been able to
let
dispute
me
that
see that
exhibit A.
The
only aspect
jail.
is the back.
Where is the provision of jail?
I don't know,
Which is that?
I don't know.
Yes, there is a provision for non-compliance, what is to be done.
There's a stay order on this honorable high court, so
That I
non-compliance
mean,
may not come in.
That, don't worry. How it is to be done, I'll do it. Right, so the wetland leader-
That's my submission for your losses considering.
One provision you are there. Yes, 29. Penalty for breach of settlement or award. Any person who commits a breach of any term of any settlement or award which is binding on him under this act shall be punishable with a imprisonment for a term which may extend to 6 months or with fine or with both. And where the breach is continuing with a further fine which may extend to 200 rupees per day, which breach continues after the conviction for the first and the court trying it so and so. Now, offense by the company, 32. See? I 30, 29 and 32. Mr. Monique, you make submission on 29 and 32. How to implement it. On the next. Thursday. Thursday.
Can it be on Tuesday? Thursday, I'm.
Thursday. Oh, don't worry. Number one appears. Don't appear. He will appear. Heard the matter in the matter has been heard at length from Mr. A. Sharma, the counsel appearing on behalf of the respondent number one, petitioner. 6, some accommodation on the ground that he would like to inquire with the learned counsel appearing on behalf of the respondent, petitioner. Learned, he would like to inquire with the petitioner as to whether the petitioner can be reinstated if this court is not inclined to interfere with the impugned award, taking into account that the depot in which the petitioner was engaged, allegedly engaged, have been closed pursuant to the, what is that term? Rearrangement, no? Or what is that term? There's a term pursuant to the rearrangement carried out, rearrangement of the company. Pursuant to the closure of the Tinsukia depot. Full stop. List this matter again for further hearing on 22nd of July 2025 at the top of the list.
Respondent number one.
Who?
Petitioner was not engaged, the respondent number one was engaged.
The workman loss.
The workman, please.
Workman told.
Obliged.
You argue on 29 and 33.
The stay on during this period, I think, therefore, non-compliance is not coming because we're protected by honorable court's interim order, staying there.
No. When I pass that order, how do I mold the relief? This is how it. Because you may come up tomorrow that we cannot put him, reinstate him. Then how do I do it?
Instatement.
Eh?
Favorably.
And do
Only that
something.
back issue for us.
Back wage is okay. Something can be done, 75% or 80%, something to that.
Supreme Court judgments, back wages cannot automatic belief being granted by a labor code. Certain conditions.
No,
have
no,
to be-
during the pendency of the proceedings before this court, you have to pay the last drawn wages. Huh?
Subject to filing of the affidavit by the workman.
Not
is managed.
necessary. Whether it is there or not.
The statutory clause itself gives that.
Go
condition
to,
precedent.
on these aspects, you should go to the division bench when I pass that order.
you know,
No, no, this
Just
has to
go
go,
there.
but this has to go finish. Anyways, on that. Any more matters? Somebody wants to do matters? Yes, which one do you want? You want to do a matter? Now, anybody who wants to do a matter, we can do a matter for next 10 minutes. I don't have the habit of rising prior to that. You want to do it?
I can,
Okay. Well, item number?
7.
Workmen. Borazanti State. You are the workman.
Workman,
You have been terminated.
I mean,
Then the matter has been heard by somebody. So many judgments? No.
we have submitted.
Termination has been held to be good.
By
Or
the
Janti State.
labor.
Hmm? Who is appearing for the respondent? No. Nobody. Huh?
In its favor.
Nobody is appearing. What is wrong? Okay, then we do one thing. Heard Mr. A. Thakudal in the council appearing on behalf of the petitioner. Full stop. None has appeared on behalf of the respondent on call. Full stop. For the end of justice, the matter stands adjourned to be listed again on, when do you want it?
2 days. Take up. For this matter, August 1st.
Listed again on 5th of August? 5th of August. It is observed that in the circumstance the respondent is not represented on the next date, comma, this court shall proceed with the disposal of the writ petition on the after hearing the petitioners. Yes. Yeah.
Challenge to an order passed by the appellate authority under section 127 of the Electricity Act.
Oh. Where challenge it? E. Bhumik. Is there?
There is no stake.
We do one thing, have it next Thursday. None appears on behalf of the petitioner on call. Mr. K.P. Pathak appears on behalf of the APDCL. This court for the end of justice, would not like to dismiss the writ petition on merit, dismiss the writ petition. And then for the inch of justice, adjourns the matter to be listed again on 22nd of July 2025. 25. Full stop. It is observed that if the respondent is not, the petitioner is not represented, comma, this court shall proceed with the disposal, shall pass appropriate orders. Yes, Mr. Todi.
Transport subsidy matter, the challenge is if there was a guideline issued by the department giving it a retrospective effect. The challenge is whether that retrospective effect can.
You're a doctor nowadays? You're a doctor? Okay. Then I have to refer you as a doctor. You're not. What are you challenging here?
Turn to page 43. annexure A5.
Satisfying partially include communication to the extent of its retrospective effect to the claim periods prior to. So you are challenging
Guideline which was issued by the department where they introduced checklist.
Huh?
Checklist for considering the claim applications for transport subsidy. As per the checklist, condition was that payments to the transporter has to be by way of a bank check. That was introduced in the November 2009. But my claims are for the periods prior to November 2009.
so the claim for now the payment is to be made by way of a bank check.
Check.
Then why are you aggrieved?
Because some parts were made in cash, so that part has been rejected by them.
Or now they say they have introduced a system by which you will only get the benefit of transport subsidy if you are paying by bank check. So earlier cash was permissible.
In a sense, yes, because there was no such guideline specifying that only bank check is permissible.
So you want that it should be made only.
Prospective, not retrospective. They have tried to bring this guideline in a retrospective form.
Let's see the guideline.
Lordship, turn to page 43, annexure A5. This is dated 20 November 2009. Checklist for scrutiny of claims under transport subsidy scheme. I am directed to say that partial modification of the department's letter of even number dated 10/9/2009 on the above mentioned subject, it is since been decided to issue two modified checklists as per annexure A and B to be applied in details hereunder.
So now 35. Bank statement for payment made to a transporter during the period. Payment only by check.
Right.
So they want to make it legal, means white, means what do you call? They want to make it
Foolproof.
transparent.
Foolproof,
Transparent.
Right.
Now you want to make it oblique, opaque.
No, because since hardly of the entire claim, 5 to 6% were paid in cash. Rest all are bank checks which have been released by them. The transport subsidy has been released to me and I have received them. Few amounts have been rejected, saying that since it was made in cash, so we won't allow it as per this checklist. Now, this checklist was introduced, as your lordship may see, on 20 November 2009 on page 43. Para 2. All claims arising for transportation of raw material finished goods prior to 10/9/2009 will be examined pre-audited as per checklist A of 44 points, where point 35 specifies bank check.
Page?
44, the checklist A.
Page 44.
Yes, checklist A, item number 35. Bank payments for payments made to transporter during the period, payments only by check.
So in respect to goods prior to 10/9, so they have given a retrospective effect. So you are challenging that.
Claims pertains to the period prior to this date, where I have already made the expenses.
I've already filed my claim applications and it was also approved by the state level committee by the Industry Department, State of Assam. The Department of Industrial Policy and Promotion. the
Where is
government
the rejection?
Rejection they have issued by way of speaking order, which is annexure 4, page 40.
Where is it?
Prior to this, I had approached this honorable court when my entire subsidy matter was withheld. Then this honorable court had passed directions to pass a speaking order on consideration of my claims. The speaking order was passed along with this annexure of table was incorporated where they have specified that cash payments has been disallowed.
Huh? No. Where is it mentioned that your cash payment has been rejected?
Lordship, page 42. Part of the speaking order, page 42 is the tabular form. The
Yes.
third column from the right, Lordship may see.
Reason for
Fourth and third
reduction
column.
of the amount.
Amount disallowed by pre-scrutiny team. Reason for reduction of amount by
Mr. Council, I'm not going to change this on this ground. With this amount being effective, because what I say here will impact, this has a far-reaching impact on the entire thing. I'm not going to do that.
No, but I challenge the entire-
I'm whatever maybe. This is on question of transparency, because you see, your amount is not so high. This is this will be almost a lakh or 1,20,000 or something. What, it is there 34,000, 59,000, 35,000 years so and so. This is the only amount.
that I-
The amount, this is the only the amount. For this, any observation made out here will have a far-reaching impact upon other industries. I'm not going to touch this. Supreme Court may do. I don't think even the division bench will do. What do you say, Mr. Architect?
Lordship may do.
Eh?
Lordship may do.
The implication, Mr. Todi, Dr. Todi, is very high.
I'm not challenging the entire guideline.
I'm very much on
Only
this,
the
more
retrospective.
particularly on the question of cash. You don't know what will have an implication with this. This is a question of only 2 lakhs. These 2 lakhs will go in crores. Not going to-
That was the reason why these guidelines had come in. But my only question is, on the date when I have made the expense, I was not aware that this is the requirement. This in fact was not the requirement at all. Once it is already done, how can I undo something which is already done? on the
You
balance?
want, I can put it that all along it should, when there is a subsidy claim, everything should have been through the bank. From the beginning, from 1971 itself. That I can pass an order.
Lordship,
Not-
Payments.
This too, I'm not allowing it. I can pass that order. That this should have been done from 1971 itself.
Lordship may only see on page 10 of my petition.
No, I'm not
What
going
was
to.
the amount
Anyways,
of total subsidy?
this judgment I'm dictating on Thursday as quickly as possible. Matter being heard at length, list the matter for final disposal on 17th July 2025 at 10:30 AM. Show me there on that day, I'll pass that order. But I'm telling you, this is a dismissal. I'm not going to do that because you see, they would have certain other implications. This has a far-reaching impact. And I also had the opportunity of practicing in tax matters. I know what is the implication.